It is 9:18 a.m. Aloha mai kako and good morning. This is the April 14th, 2021 Land Use Commission meeting, which is being held using interactive conference technology, linking video conference participants and other interested individuals of the public via the Zoom internet conferencing program. We're doing this in order to comply with state and county official operational directives during the COVID-19 pandemic. Members of the public are able to view the meeting through the Zoom webinar platform. For all meeting participants, and this is really important, I really want to stress to everyone the importance of speaking slowly, clearly, and directly into your microphone. It helps if before speaking, you state your name and you identify yourself for the record. Please also be aware for all meeting participants, you are being recorded on the digital record of this Zoom meeting. Your continued participation is your implied consent to be part of the public record for the event. And if you do not wish to be part of the public record, you should exit the meeting now. The Zoom conferencing technology allows the parties and each participating commissioner individual remote access to the meetings via our own personal digital devices. So also please note that due to matters entirely outside of our control, occasional disruptions to connectivity may occur for one or more members of the meeting at any given time. If such disruptions occur, please let us know, and please be patient as we try to restore audiovisual signals to effectively conduct business during the pandemic. For any members of the public wishing to testify during the public witness portions of any of the dockets and who are accessing this meeting by telephone rather than by software on a smartphone or desktop, use *9 to virtually raise your hand or *9 to virtually lower your hand. And you can use *6 to request to be unmuted. From time to time, I will be asking for breaks. My name is Jonathan Likeke Scheuer, and I currently have the honor and pleasure of serving as the Land Use Commission Chair. Along with me, Commissioners Ed Axon, Don Chang, Gary Okuda, Arnold Wong, our LUC Executive Officer, Daniel Oradenker, our Chief Planner, Scott Derrickson, our Chief Clerk, Riley Hakoda, and our Deputy Attorney General, Dan Morris, our Program Specialist, Natasha Quinones, are all on the island of Oahu. If you've been here since 9, you know that we are trying to be joined by our court reporter, Jean McManus, who is also on Oahu. Commissioner Nancy Cabral is on Hawai'i Island. Commissioner Lee Ohigashi is on Maui, and Commissioner Dan Giovanni is on Kauai. We currently have 8 seated commissioners of a possible 9. Our first order of business is the adoption of the March 24th and 25th, 2021 minutes. Mr. Derrickson or Mr. Hakoda, has there been any written testimony submitted on the adoption of the minutes?
Mr. Chair, this is Riley. No public testimony on the minutes.
Okay. Are there any members of the public who are attending the meeting who wish to testify on the minutes? I see nobody's calling in by phone. So if so, use the raise your hand function on the Zoom platform if you wish to testify on the adoption of the minutes. Seeing none, commissioners, any questions or comments? And if none, a motion? Commissioner Cabral?
I'll make a motion to adopt the minutes for the March 24th, 25th meetings.
Thank you. Is there a second?
Chair, this is Commissioner Wong.
Yes.
I second.
Thank you, Commissioner Wong. So we have a motion by Commissioner Cabral and a second by Commissioner Wong to adopt the March 24th and 25th minutes. Are there any comments or discussion? If not, will all the commissioners please say aye and raise your hand to vote yes?
Aye.
All in favor? Are any commissioners opposed? If so, raise your hand and vote nay. Seeing none, the minutes are adopted. Our next agenda item is the tentative meeting schedule. Mr. Oradenker.
Thank you, Mr. Chair. All meetings are by Zoom unless we have a change in the circumstances. Tomorrow, we will once again be meeting to discuss the Maui GRIER motion if we do not complete that today, and begin retake the Hokua Place matter, up the Hokua Place matter. On the 28th of this month, we will be meeting to discuss the Kamalani motion to extend time and begin the process of examining the Oahu IAL submittal by the county. April 29th is also set aside for the Oahu IAL matter. On May 12th, we will be taking up a special permit matter on Maui, Pohakea, SP 06400. That is also scheduled for the 13th, and we will also be taking up the IAL matter if necessary, or the Hokua Place matter, again, if necessary. On May 26th, we'll be taking up the AES West Oahu solar matter, special permit. Also, if complete that matter in time to take up more of the IAL matter if necessary. On the 27th, we will also be doing the West Oahu solar matter and IAL, as well as any matters associated with Hokua Place if necessary. On June 9th, we will be taking up the Kula Ridge matter on Maui, and June 10th, tentatively. June 23rd and 24th, we have set aside for the Hokua Place matter, and that takes us to the end of our scheduled calendar. At this point, everything else is tentative.
Okay. Commissioners, any questions for Mr. Ordenker about our schedule? Seeing none. Our next agenda item is the adoption of the order for docket number A18-806, Berry Trust Hawai'i, an amended petition to amend the land use district boundary amendment, boundary of certain lands situated at Kea'au, Puna, County and State of Hawaii, consisting of 0.51 acres from the Conservation District to the Agricultural District. Tax map key number 31-559, lot 59. Mr. Hakoda, has there been any written testimony received on this matter?
Mr. Chair, this is Riley. No written testimony on this matter.
Okay, are there any members of the public who are attending this meeting who wish to testify on the adoption of this order? If so, use the raise your hand function. Seeing none. The commission will now proceed to adopt the order. Before we take up any motion, I'd like to confirm as the chair for the record that all the commissioners and myself are prepared to participate and deliberate in these proceedings. Commissioner Chang, are you prepared?
Mr. Chair, yes, I am prepared. Thank you.
Thank you. Commissioner Axon.
Yes, I am.
Commissioner Cabral.
Yes, I am.
Commissioner Okuda.
Yes, I am.
Commissioner Wong.
Yes, I am.
Commissioner Ohigashi.
Yes.
And Commissioner Giovanni.
Yes.
The chair is also prepared to participate. We will now consider adoption of the order. Commissioners, before you, for your consideration, deliberation and adoption are the proposed findings of fact, conclusions of law, and decision and order prepared by the staff as instructed at the last meeting on this docket. Is there any discussion? Seeing none, I will now entertain a motion to approve the form of the order for docket number A18-806, the findings of fact, conclusions of law, and decision and order for the Berry Trust Hawai'i, their amended petition to amend the land use district boundary of certain lands situated at Kea'au, Puna, County and State of Hawaii, consisting of 0.51 acres from the Conservation District to the Agricultural District, tax map key 31-559, lot 59. Commissioners, what is your pleasure? Commissioner Cabral.
I move that we adopt A18-806 as stated by our illustrious chair.
Thank you. Is there a second? Commissioner
Second.
Ohigashi.
Second.
Okay, Motion's been made to adopt the order, approve the form of the order by Commissioner Cabral and seconded by Commissioner Higashi. Is there any discussion, members? Commissioner Cabral?
I would like to speak to this motion, but more so since it's not too controversial. For somehow strange reason, I reread all 55 pages of the information last night of all about this and the summary. And I've got to say that it's just amazing the amount of work that has gone into this 0.51 acres of property. And the fact that this has got to be, I don't know, the most documented small piece of property I know of, and the berries for their patience. And I can't even imagine their expense in order to transfer what they thought was going to be a regular lot among 8,835 other parcels of land that they could build a house on. And instead they've met bureaucracy to the nth degree. So I gotta say that I almost feel like we should create a binder for these poor people and let them know they've got the most documented piece of property, and also the fabulous job that everybody has done in terms of our LUC staff on providing information to us. I now know more about their land than I do my own. So thank you very much to everybody.
Thank you, Commissioner Cabral. Is there any further discussion? Seeing none, Mr. Ordenker, please poll the commission.
Thank you, Mr. Chair. The motion is to adopt the order in this matter as presented by staff. Commissioner Cabral,
Yes, yes.
Commissioner Higashi,
Yes.
Commissioner Chang,
Aye.
Commissioner Giovanni,
Aye.
Commissioner Axon,
Yes.
Commissioner Okuda,
Yes.
Commissioner Wong,
Aye.
Chair Schreier.
Aye.
Thank you, Mr. Chair. The motion passes unanimously with 8 affirmative votes.
Great. Thank you. Thank you, Mr. Simon.
Thank you, Chair. Thank you, Commissioners, and thank you, staff and parties for all your hard work on this. The bears and myself are very appreciative.
Yeah. Thank you very much to you and your clients, as well as to Hawaii County. We appreciate it. I will take a 1-minute recess while y'all leave the virtual room. And before we move on to our next agenda item. 1 minute.
Aloha.
Aloha.
Thank you, everyone.
Yeah, goodbye, Big Island people.
Are you available? Okay, Commissioner Axon. Okay, great. We're back on the record. Our next agenda item is for docket number A11790, Kula Ridge LLC, Maui. To consider the status of docket number A11790, in which the Commission granted the redesignation of approximately 34.516 acres of land from the agricultural district to the urban district, and approximately 16.509 acres of land from the agricultural district to the rural district at Kula, Maui, Hawaii, for a mix of residential, park, and open space uses. Will the parties please identify yourselves for the record?
Yes, good morning, Chair and members of the Commission. My name is Tom Welch, Mancini, Welch and Geiger, and I represent the Raymond M. Bontemsky Marital Trust, the present owners of the property.
Thank you, Mr. Welch. Maui County.
Michael Hopper, Deputy Corporation Counsel, representing the Maui County Department of Planning. I have Deputy Director of Planning, Jordan Hart, on the line with me.
Okay, welcome to both of you. Mr. Yee.
Good morning, Deputy Attorney General Brian Yee on behalf of the Office of Planning. With me is Rodney Funakoshi and Aaron Sotogawa from the Office of Planning.
Okay, and I believe we might have our court reporter here now. I think we have visual contact. Perhaps. In any case, the meeting is being recorded. Let me now update the record. On February 9th, 2021, the commission received an attorney inquiry letter from Mancini, Welch and Geiger LLP. On April 1st of this year, the commission emailed the meeting agenda for the April 14th and 15th, 2021 meetings to the parties in this docket and to our statewide and county lists. On April 5th, the commission mailed the meeting agenda to the parties in this docket. Let me briefly go over our procedures. First, I will recognize anybody who might wish to testify on this matter. If anybody wishes to testify on this matter, I will bring them into the meeting room as a participant, swear them in, allow them time to speak, the length of time which can be cut short at the chair's discretion. And then those witnesses will be available for questioning, if any. After the conclusion of questionings from any public testimony, the chair will call for a status report from the petitioner. I will then call on the County of Maui and the Office of Planning to speak to the status of this docket. At the conclusion of any presentations and after any questions from the commissioners and answers to those, the commission can conduct deliberations on this matter. For any members of the public who are listening in, please be reminded the commission in this status update will not be considering the merits of A11 of the Kula Ridge LLC petition, but instead just learning about the current state of activities related to the docket, including the compliance with any conditions the LUC placed. Are there any questions on our procedures for today from the parties? Petitioner? Mr. Welch, any questions?
Yes, I have no questions. Thank you.
Okay, County.
No questions, Chair.
OP.
No questions.
Mr. Hakoda, as of yesterday, there was no written testimony on this matter. Is there any that has been submitted?
This is Riley, Chair, no further public testimony.
Okay. Are there any members of the public who are attending this meeting in the Zoom webinar platform who wish to testify on this matter? If so, please raise your hand using the raise your hand function. Seeing none, there's no public testimony on this matter, and Mr. Welch, you may proceed with your presentation.
Thank you, Chair. I represent the present owners of this property. They had sold this property several years ago to Clayton Nishikawa, who planned to develop this property through the Kula Ridge LLC, which I believe was the petitioner, the original petitioner in the district boundary amendment that was done several years ago, and pursuant to a decision and order dated February 21, 2012. The project wasn't able to proceed after a lot of effort, and the present owner took the property, actually had financed by seller financing a portion of the original purchase price, and on January 7, 2020, last year, they took the property back, the ownership of the property back by deed in lieu of foreclosure. So they are now, again, the owners of this property. Over the years, since 2012, as I mentioned, the Kula Ridge project did not go forward, and none, as far as I know, none of the conditions of the commission's decision and order were satisfied. I don't think the time period is quite over yet, but I can assure you that there's no possible way that it will be satisfied by the deadline. So the owners, the present owners, desire that the district boundary amendment from 2012 be reversed, and that the project, the land district land use designation revert to agriculture, both lots. And that's our request.
Thank you very much, Mr. Welch. Commissioners, are there questions for Mr. Welch. Commissioner Okuda.
Thank you very much, Mr. Chair. Thank you, Mr. Welch, for being present. I have a couple of questions. Do you agree that the Land Use Commission order creates covenants which run with the land?
Yes, I do, Commissioner Okuda. It's recorded on the title, and it is runs with the land as an encumbrance that I believe encumbers the property and obligates the owner of the property to comply with them.
And when a person or an entity receives title through a foreclosure action, whether it's a commissioner's deed after a judicial foreclosure or a deed in lieu of foreclosure, the grantee, whoever the grantee is, it could be a new party, or it could be the owner, or it could be the party financing the transaction. Whoever is the grantee under a deed in lieu of foreclosure or as a result of a foreclosure would be subject to those conditions. Is that correct?
Yes, that's correct. And the reason is that when the D&O was recorded, it was approved and executed and accepted by the then present owners of the property. So it attaches to title. And you could argue, I suppose, that if the mortgagee didn't enter into it or approve it, they might be able to argue that it doesn't apply to them. However, it does encumber the title, and it makes it difficult for someone to accept clear title to the property if it were to be sold. So, for all practical purposes, yes, I agree with you.
Yeah, I know there might be a debate in the law. There may not be clear precedent in Hawaii to what extent a subsequent grantee is personally obligated to perform the condition. But let me ask you this. Did any of the conditions that were recorded as part of the D&O or recorded on title require the building of affordable housing or housing which was intended to benefit the residents of the county of Maui?
The answer to that is yes, Commissioner Okuda. The D&O required the construction of 70 units of affordable housing.
And based on, I think, common knowledge, I don't want to say there's like judicial notice here, but there still really is a need for affordable housing in the county of Maui, correct?
I would certainly agree with that, Commissioner.
Okay, well, whatever happens in the future, it won't be decided here today. I'll tell you what my concern is. My concern is the Land Use Commission gives these approvals for boundary amendments. A lot of times the promises, and I know it's not your client that made the promises, but the promises are made to do certain things as a condition of getting the boundary amendment. And for whatever reason, sometimes, maybe many times, the conditions aren't met. And there seems like there's no real consequence for that, except the only consequence is to the community that might have had an expectation that there would be, for example, affordable housing. And many times this housing is really not cheap housing. You know, it takes local residents to really scrimp and save to get in there, but even that type of housing isn't produced. And then applicants, and I'm not criticizing you, Mr. Welch, because, you know, I mean, I can see why you are bringing this request, but a request is then brought to the Land Use Commission to ask to be relieved of a condition that was represented and promised to get the boundary amendment in the first place. And you don't have to answer this question today, but the question I have and probably will continue to have in this case is, instead of a reversion back to an agricultural boundary designation, shouldn't one of the remedies be that the county of Maui or somebody with standing bring an action for specific performance to require that the conditions be performed. And you don't have to answer that today. That's just a comment. And you answered the questions I did have. You can respond if you want, but otherwise, Mr. Chair, thank you. I have nothing further to add or say.
Okay, Mr. Welch, did you wish to respond to Commissioner Okuda's statement?
Yes, briefly, Mr. Chair. Commissioner Okuda, as a practitioner in Maui, I share your sentiments completely about the affordable housing commitment and need. If there's a way to do it, to pass this on to a developer that could meet the conditions in the time frame, I think that would be a very good result. One of the reasons, as I understand it, that the project couldn't go forward is that the infrastructure, the county's infrastructure for water and so forth, was not able to be provided for various reasons, and the project just wasn't able to go forward. So, so I think, and my clients are disappointed that the project didn't go forward, but they don't see that they don't have the financial ability to do it, and they don't have any possible takers in the market to buy this and be able to develop it. So I think we're stuck on this one, unfortunately.
Commissioner Chang.
Thank you, Mr. Chair. Thank you, Mr. Welch. I just have a few questions. So it's my understanding the intention of your client is essentially just to have the property go back to what it was prior to the DBA. And it would just be kept in agricultural use. Is that correct?
That is correct.
Does your clients live in the area?
It's a large family, and some of them do, but many of them don't.
What is the current use of the property?
It's just vacant land. The people may do some grazing on it, but I don't believe it's being used actively for any commercial purposes.
Okay, and I guess I share some of Commissioner Okuda's comments, and I'm just wondering, has your client explored, and you may have already answered this, given the change of zoning for another potential developer to come in and do the development either as originally intended or presented to LUC or modified, but has your client or the counties, and I'll ask the county the same thing, explored looking for an alternative developer to do the project?
That's a good question. My client has not. My client isn't in the land development business or anything, and doesn't have the financial resources to pursue it themselves. I believe that Clayton Nishikawa, after failing to move forward over some time, has tried to come up with financing and other development options and other possible developers that could take over his position. So I think an effort has been made along those lines, and I can't testify to whether he did a good job or not a good job on that process. But I think I think my general understanding is that that the project can't go forward as a practical matter, and we don't have people knocking on our door to take it over and do it.
Okay, it just seems unfortunate given the expense, because if the land is reverted back to agriculture and in the future, some future developer decides to do a similar development in this area, they will have to go through the DBA process and all of the regulatory requirements all over again. So, okay, and perhaps the county, I'll ask them this, whether they know of any other developer. And if there were, would your clients be open to negotiating something with a prospective developer to complete the project?
I haven't discussed that with them, but I can raise it with them if the situation requires.
Okay, no, thank you very much. You've answered my questions. Thank you.
Thank you, Commissioner Chang. Commissioners, further questions for Mr. Welch at this time? Commissioner Axon.
Thank you, Chair. Good morning, Mr. Welch. I'm just kind of wondering, what is your client's motivation or plan when they purchase or when they take over this property, knowing that there are efforts to develop it and still your client decided to take it over?
I understand that they would probably sell it.
It's a very expensive land to just sit on it. So I'm just kind of wondering, there's got to be something that, motivate or a reason for your client to purchase this. It can't just be sit on it. I'm just kind of wondering, the motivation on this one.
Well, they, if I could respond to that, they took the property back essentially in foreclosure because Kula Ridge LLC, Clayton Ishikawa, failed to, was in full default in paying his financial obligations for the original purchase price of the property. And so by taking the property back by deed in lieu of foreclosure, they were protecting their financial interest, and particularly in light of the fact that the possibility of Clayton proceeding with his development or selling it to another developer seemed impossible at this point. So they took the property, and now they own it, and they've got to deal with it.
Yeah, I understand that Mr. Nishikawa made a lot of effort on trying to develop these, talking to other developers, but what kind of efforts your client did once taking over the property? And I guess with that, I'm just kind of wondering if there is a possibility. I know they tried already. If there's a possibility another developer can take it over, or developer wants to develop it, and the commissioner instead extend the. I know you had some concern about the deadline on trying to meet those orders. If there is somehow a developer willing to take it, wouldn't it be better to just ask for extension?
If the county were able to supply this property with water service, then it could be developed. But as I understand it, the infrastructure and utilities available to this property are not sufficient without a substantial additional investment that would render affordable housing project financially not feasible. That's what I understand. I haven't looked at the numbers, but that's my general understanding of what happened.
Yeah, I guess the other question is for the county. I know Maui, like Oahu, has a real need of affordable housing. I'm just kind of, hate to see this just, go down to nothing. And perhaps maybe the county or the state, can do something to develop this property. For example, by the county moving forward with any infrastructure needed for this property to develop. Was there any conversation with the state or government agencies, like the county of Maui, about possible partnership or possible working relationship on trying to make this happen? Let me rephrase that. Is your client had conversation with any agency, county, HUD, or any government agencies to see if they can give you some possible options on what, to help to make this affordable housing a reality?
The question's to me. My client is not in the development business. It's a family trust. They're just not in that business. I don't think they would know what questions to ask or how to even approach it. It would need a third-party developer with knowledge and experience and financial resources to come in and be able to proceed with a project of this kind on this land.
Yeah, that's all I have, Mr. Chair. Thank you.
Thank you very much.
Mr. Welch.
Thank you very much, Commissioner Axon. Commissioners, are there further questions for Mr. Welch at this time? Commissioner Ohigashi.
Yeah, maybe our lawyer can tell me if I'm out of bounds or anything like that. But Mr. Welch, did the Von Tempsky Family Trust have any interest in the development of this property along with Kula Ridge LLC?
I don't believe they were an equity partner. They did have an interest because Kula Ridge LLC owed them a lot of money on the purchase, the original purchase. So they were certainly interested in its success.
Other than the sales price, I'm just talking where they're an equity partner or they have some kind of payout interest or some kind of interest should the completion of the project occur.
As far as I know, they've never had any interest or participation with Clayton or his LLC.
And so, if I remember correctly, well, let me put it this way. I just growing up here and knowing the reputation of Von Tempsky's family, it would appear that they're not seeking to, like so many other people seeking to enrich themselves on the obtaining of the Land Use Commission designation. And I think that if you cannot develop it, I'm glad that the Von Tempsky family is looking to return it to agriculture. That's my comment.
Thank you, Commissioner Ohigashi. Commissioners, is there further discussion or questions for Mr. Welch at this time? If I can briefly, Mr. Welch, the property was entitled by the Land Use Commission after Maui County had already passed its changes to county ordinance that are popularly known as the Show Me the Water rule. Is that correct?
I wasn't involved at that stage, but I know that as I remember from general understanding in the community that Clayton Nishikawa was planning to develop a water system with a well for this and another property that he had also bought from another group of Von Temskis nearby. Whether that went forward or whether it was successful or not, I don't know. But so I'm not sure, and I wasn't around and wasn't involved, so I don't know how he satisfied the show me the water.
But my question is that to be specific, condition 11 of the DNO makes specific reference to the show me the water rule. So the fact that water would be required for this development and that the developer had an obligation to show that it was required is not a new development post entitlement, but actually it was something that was known at the time, correct?
I think that's correct.
Okay.
It was.
Thank you.
But it's just if I could amend that, as I understand it, it's a financial commitment that burdens the property and the development. And the question is, can you spend the money, develop the water system, and complete the project in a way where you're not going to go bankrupt?
Thank you. Can I ask you, most of my questions have already been asked by other commissioners. Did your client receive some payments from the original petitioner, Mr. Nishikawa's firm, as part of this transaction?
I expect they received interest. I haven't asked them that question, so I can't answer it specifically.
So they may have received some financial benefit.
Yeah.
And I'm interested in whether the amount of financial benefit they received was related to the LUC's entitlement of the property.
The property was sold prior, and the promissory note was signed prior to Kula Ridge LLC proceeding with the Land Use Commission to change the land use designation. So the price that they received and the interest on that debt would not have benefited from the fact of the land use designation having been changed, because it wasn't changed until after the note was executed and the purchase of the property was completed.
And there was no way in which the sale was reversible or conditioned upon entitlement from the Land Use Commission?
No, it was a deed, a final deed, and it was a promissory note was provided, and the note was secured by a first mortgage on the property to secure the repayment of the note.
And the date of that is what date, do you know?
The date of the sale?
Yes.
Let me look. I think I can tell you quickly. It was 2005, October 12, 2005.
Thank you very much, Mr. Welch. I have nothing further at this time. Is there anything further, commissioners? If not, it's 10:03 a.m. And while we did get a slightly late start, I would like to take a 10-minute break prior to continuing with a presentation from the County of Maui. It's 10:03. We will reconvene at 10:13. 10:13. We are back on the record. Mr. Hopper, how are you?
Good morning, Chair. It's still morning.
Nice to see you. It is definitely still morning. We have an hour and 46 minutes in which we could question you and still be morning. So why don't you proceed?
Thank you, Chair. We do not really have a presentation in this situation. We had access to the same information that the commission had. The letter from the current landowner was February 4th, so still relatively recently, and we've have access to the annual report. So I think we have the same information that you have, and at least the planning department does. So we don't have much to add to what the current landowner has provided. We're here to get that information as well. If there is additional information that the county of Maui, not just the planning department, but other departments could provide, I think we can look at doing that if there's questions that you'd have as part of this docket. But otherwise, we're getting, I think, the information at the same to the same extent that you are from the developer and the landowner and their current plans for the property. And so right now we don't have much to add to the record other than we're here to listen and understand where the project is at right now.
Okay. Thank you, Mr. Hopper and Mr. Hart. Any questions for the county? Commissioner Chang.
Thank you, Mr. Chair. Sorry, I have a barking dog in my background, so bear with me.
The things that Zoom has brought to us, you know? So
you're absolutely right, Mr. Chair. Mr. Hopper, I'm going to have I'm probably going to have a much longer speech than I'm going to have a question. But first question, has the county relied on any of the conditions in the original DNO for any of your, county planning matters? Have you relied upon anticipating that this developer was going to increase the water capacity so that the county would be able to build, to do more things up in Kula? So that's the first question. Have you relied on any of the conditions in this docket in making your Maui County's planning decisions related to this area?
Commissioner, I do not believe so. We could check with Department of Water Supply and the current owner, but my understanding is that there were, if you read the decision in order, there were several options that the landowner could have undertaken to develop water. One of them was if they developed their own well, they could get credits, and the county would potentially use that well for the upcountry water meter. But there were other possibilities too. One was to just get on the upcountry water meter list and be have county water. And so I don't think from reading the annual reports any of those options were completed, because it was my understanding is that there's not been the subdivision approval yet. And prior to that, the water conservation or the water plan would have had to have been set forth. So to my knowledge, no, with respect to water anyway, there hasn't been anything like that, because when I read the decision in order, there were a variety of options. As far as what was discussed with the department by the developer, we could check on that. I don't have specific information on that, but again, there were a variety of options, and it appears none of them were, the developer was not successful in completing any of those because of the challenges with developing water upcountry.
All right. And this is going to be where I'm going to probably give a little bit of my own little speech here, but I do have a question for you at the end of it. In my view, a change of boundary designation, especially from ag to urban or rural, is a privilege. And we as the land use commissioners have an obligation to ensure that one, the conditions are met, and that the decisions are really in the best interest of the community, because this is public land. And over the last several, different dockets, I have been dismayed by several of the petitions that have come in to change or modify amendments to the original DNO, because developers have subsequently determined that they're unable to do what was originally planned. And in many circumstances, the land has gone through numerous owners. So the petitioner that comes before us today may not be the original developer. So my question is, in the future, if we included in our land use, as a condition for boundary amendments, the condition that the developer pay a performance bond, in particular for the infrastructure, to ensure that if the infrastructure is not built, at least in this case, the county would have a source of funds to do some of that infrastructure development. I see that there is value in the change of designation. And that value is because you're able to do a lot more with the land when it's changed to either urban or rural from agriculture. Too often I have seen developers come in, do some of the market, the more, the development portions that provide them a very quick revenue, and then they leave. So a lot of the kinds of conditions, affordable housing, infrastructure, are not completed. So my question to you as the county is, would the county find it would you be in support of the Land Use Commission, including in the condition, the payment of a performance bond, so that to ensure that those infrastructures are either developed or that there's revenue for the counties to develop those particular infrastructure. So that's my question to you, Mr. Harper and Mr. Hart.
I think the idea of a bond is, I mean, I think in county entitlements, that's something that's looked at. As far as the bond then having the county build the infrastructure is where maybe is a little difficult to me, because, you know, then would the county be responsible for developing the remainder of the project? And obviously, if you just built the infrastructure and the rest of the project couldn't be developed, would you have, you know, roads and things that wouldn't be, you know, so conceptually, I can check with the department, and, you know, that'd have to come up in other dockets, obviously, because this one's already completed, but we could look at something like that. And like I said, like I said, this is something that that the county, I think, does have that as part of its change in zoning as an option to have bonds for items like that. But I think the idea is not necessarily that the county would complete the project, but that a bonding company would then either through performance bond or payment bond, you know, pay for those infrastructures to be built. Who would build them? I don't think that it would be the county necessarily building them. So that's where I'm a bit iffy, but we can look at something like that, and I can check with my client directly on that and see for future dockets.
And I may have made a wrong assumption having the county build them. It's more having a source of funds for the county or an appropriate governmental body to determine the best use of those funds, especially in the case of water. Would it be to upgrade a water system? Would it be to improve particular roadways? But there is, you know, government lacks sources of funds to do necessary infrastructure. And it may, while you may not be doing the development, having a source of funds to put in some of this infrastructure may better equip government, whether it be, you know, the state, the county, or making the land much more attractive for a, you know, the county to do a, you know, like a HUD housing project or something. I don't know. My only point is to hold this developer responsible, financially responsible for its commitment when we do a boundary amendment. Because at this point in time, there really is no hook other than a reversion, or they walk away from the project because they can't do it. So I would just like you to think about it, because that is something that for me, I will continue to inquire about and possibly make it as a condition on future boundary amendments. All right, thank you, Mr. Hopper.
Thank you, Commissioner Chang. Commissioner Ohigashi.
Mr. Hopper, my understanding is the Land Use Commission is limited in its abilities in this matter, and our only remedy in this type of case is a reversion. So I'm going to ask you some ideas about substantial commencement. Were there any offsite improvements that were required by the County of Maui and that was done or completed by previous developer? Because my recollection was something about a water line up in Kula going to Hawaiian homes during that period of time. And I'm not sure if they contributed to it or they didn't contribute to it. So, and if you don't have it, I'm sure that you can find out about it before the next hearing.
Yes, I'm sorry, Member Hoigashi, I don't have that information right now if there's been substantial commencement. Well, the specific question as to that upgrade, I don't have that. I do have the status reports, and the response to almost all of them is that we will comply with the condition, but really with nothing specific done. So my understanding, and perhaps the petitioner has additional information, is that really not much has been done as far as building the infrastructure. And obviously the landowner's position appears to be that there has not been substantial commencement because they've requested reversion. But I understand your question, and we can I can check with water supply specifically, or if there's any other agencies. I could check with Public Works to see if there's anything been built. But my understanding from the annual reports and from the petitioner's letter is that really nothing's been done as far as developing the infrastructure, but there may have been some things, so we can check on that.
And so, and hypothetically, I'm going to ask you this hypothetical question, is that assuming that we do not revert in this type of cases, does the County of Maui have a mechanism to enforce the terms and conditions of the Land Use Commission, DNO? And if so, what are they?
Well, it's certainly difficult if the landowner's position is that they have neither the financial capability to do it nor the wherewithal. But the code, the state law, I should say, I think allows for fines, and they could be issued a violation. But I mean, I think again, that can be difficult in a situation if there's no capacity to develop. I mean, you're bringing a lawsuit to or fining somebody, and I don't know. I mean, you could be fining somebody a certain amount per day, but the cost of the infrastructure could be substantially more than that. So there could be challenges there. But I think that under the law, there's the ability, there's an opportunity to fine somebody who is not in compliance. But I do think reversion is in the statute, the mechanism that the commission anyway would use to enforce if there's not substantial commencement. So there are some options as far as enforcement in addition to that, though, which include fines and potential legal action. But again, that can be difficult if there's no possibility for the project to be built.
And just curious, who would make that decision in the county?
I think the under the code or under the state statute, the planning department has enforcement authority for land use commission dockets.
Thank you, Mr. Hopper.
Anything further, Commissioner? No. Commissioner Okuda.
Thank you very much, Mr. Chair. Mr. Hopper, if this matter proceeds to a further hearing at some point in time, I would be interested to know what the county believes would be in the best interest for the residents of the county from a general planning matter. You know, I know that if there's no substantial commencement of the use of the property in accord with the representations, the Land Use Commission can simply revert the property without complying with the standards under Chapter 205. But I would still be interested to know what the county would, from a long-term planning standpoint, would think it's in the county's best interest. So maybe you can just make a little note of that on the side. And related to that, you know, a couple of questions I have, and you don't have to answer it today, is whether or not the county believes that in the appropriate case, it would have as a remedy a lawsuit for specific performance. As we all know, specific performance is getting a court order to order somebody to do something, usually what they promised to do. And if they don't do it, there could be court sanctions. And sometimes it might even rise to a level of contempt of court with all the sanctions that involve contempt of court, which might even be more than a simple fine. And I'm not sure if just because you transfer title out through a deed in lieu of foreclosure, you can escape you know, the reach of the court for specific performance. So at some point in time, if you can make a comment regarding that. And the other thing at the appropriate time, if you can make a comment about whether or not there are sanctions that could be imposed for people who file status reports with the Land Use Commission where they knew or should have known some of those statements, or maybe a lot of the statements being made in the status reports are either not true or omit material facts. For example, I know many status reports say, we will comply, we will comply, we will comply with certain conditions, but it seems that oftentimes these statements are made when the person who signed the status report knew or should have known that that really wasn't the case. There was really either no intention to comply with the condition or no ability to comply with the condition. So my question is whether or not the county believes there's some type of sanction that can be imposed or involved regarding that type of situation with status reports. Look, I'm not suggesting criminal prosecution, and I really haven't really done criminal law, but I think there is this crime called unsworn falsification to a government entity or official. So if you can just keep those questions or points in mind as we proceed further. Thank you, Mr. Chair. No further questions.
Thank you, Commissioner Okuda. Commissioner Hopper, did you want to respond at all? Mr. Hopper, excuse me.
Again, there's are three questions that I got there. One was about the county's long-term position. The other was a lawsuit on specific performance, and the other was sanctions for filing status reports. And I appreciate Commissioner Okuda recognizing that they may not have answers to all of those immediately. As far as the long-term planning issue, I think we can check with I can check with my client, the planning department, on that to see if they've got a additional thoughts on that before it sounds like we're going to have another meeting on this in a couple of months, so we can look at that issue, and we can think about the other items that you raised and provide our thoughts on those as well.
Thank you. Commissioners, anything further for the county?
Chair.
Commissioner Wong.
Just one question for the county. I just wanted to reaffirm that this was a 201H project. Is that correct?
That's correct.
And there's a timeline for 201H that passed. Is that correct?
I can check the resolution for that 201H. I can double check that. I don't recall there being, I don't know if they put in a deadline on that. or not. But there was a 201H resolution, and we can check that. My recollection was that that was done prior to the Land Use Commission's approval, but would also potentially be at issue here if there's no plans to develop further. But I don't know if that had any timelines on it as far as the Land Use Commission's 10-year infrastructure deadline.
Okay, no, I just thought that 201H has a specific time that you have to build affordable housing. That's all I just wanted to know in the county's statutes.
I think it would be the state law, and I can check the resolution. I think that would be specific to the reso.
That's no problem. That's all I need to ask. Thank you, Chair. Thank you, Mr. Hopper.
Thank you. Commissioners, anything further? If there's none, let's hear from the Office of Planning. Mr. Yee.
Planning has nothing to add on this matter of the status conference. Happy to answer any questions.
Okay, commissioners, questions for the illustrious Mr. Yee? Commissioner Chang?
Sorry, I lost my raised hand. Mr. Yee, I'm hoping you heard the line of questioning that I had for Mr. Hopper. Do you have an opinion on that?
I think we're developing a more formal position and perhaps a clear position. If it would be helpful, let me offer some initial thoughts. The issue of bonding is, we think, problematic on a practical level. The Land Use Commission, put differently, it may be more appropriate for the county to impose bonding requirements when they're much closer to construction. And the reason is because of the time periods that can be involved. The Land Use Commission occurs very early in the land use process. And the time of construction, and more importantly, the sale of units in which the project can generate income, can often be quite far down the line. So the requirement of a bond at the land use stage would significantly deter, we think, any ability to get developers to move forward. We also think that the enforcement mechanism is uncertain to us. The Office of Planning is certainly not going to enforce the bond. We're not going to be constructing developments. The county it doesn't intend to do it either. And at a certain point, you do have to be careful of the takings question. So when you require an obligation which exceeds the impact which the applicant causes, or put differently, the conditions that are posed are supposed to be reasonably related to the impact caused by the development. If there is no development, then what's the impact that's being resolved by the bond, or what is the impact being mitigated through the bond? It could be different if the development proceeds, you build everything, but they don't put in the, let's say, traffic infrastructure. At that point, I understand there could be a bonding requirement, and it could survive a constitutional takings challenge. But if they don't construct, then a requirement to build infrastructure would be to mitigate an impact which doesn't exist from the development. And that could create then, there is no relationship between the mitigation and the impact, and the amount of the requirement. It would be arguably out of proportion to the amount of the impact of the project. So we think that there are, obviously this is just a conceptual proposal, so we haven't seen what would actually look like. When would the bond be required to be paid? Who would have to enforce it? I mean, these are issues that haven't been fully fleshed out. But I think we have some initial concerns about how it could work, given the fact that the Land Use Commission occurs so early in the land use process, and that there is a county process still to go. So that it does appear to us that the county may be the better authority or the better form in which a bond could be imposed, because they occur so much closer to construction. Thank you.
And Mr. Yee, I greatly appreciate your thoughtfulness and taking that, seriously. I hadn't thought about the taking issue, but these are some of my comments in response. One, I think that there needs to be some kind of acknowledgement that there is reliance on the part of the community and on the part of the Land Use Commission when representations are made by a developer that this is their proposed project. In my view, I think the developer, they present to us a set of facts that may not necessarily represent the true cost of the development. And the community is asked to, to have this land use designation changed. They are bearing the burden of increased traffic, of increased use of water, sewer, all of the infrastructure. They are having to bear that burden. And this is all based upon representations made by developers that they are going to improve the infrastructure that is potentially that they are potentially impacting based upon these environmental impact statements. If I would ask you if you are going to be rendering a more substantial opinion, that if you don't think that the bond is the right approach, I think you obviously know how I feel. I would ask you to come up with some alternative suggestions. How do we ensure that developers are going to do what they say they are going to do? Because, it really, it weighs very heavy on me when communities come in 10, 20 years later, after the developer has developed their market property, and then they've left. And these communities are holding, and they've made substantial concessions to have this developer come in. So again, my only request to you is if you find the performance bond not to be an appropriate tool for the Land Use Commission, knowing what my concerns are, I would appreciate some alternative options for the Land Use Commission to consider as it weighs these DBAs. All right, thank you very much, Mr. Yee. I greatly appreciate it.
If I could just give one sentence, and just there may be a difference in our view of what can be done to remedy construction and development which occurs and failure to comply with the mitigation requirements versus a case in which no development occurs. The second one is the more difficult issue, we think, on this question. So we'll be happy to address those
Okay.
two.
And I would agree with you, but in my view, there is value given for the change of designation. There has been probably reliance on the part of the community for that change in designation. There may even be reliance on the part of the counties in their future planning based upon those representations. So even though the development is not done, and so when there is an issue of reversion, there may still be some injury to the community in light of the fact that the developer 10, 20 years later says, we can't do it. So just think about that as well. There may be different remedies for different stages of the, the process. Thank you again.
Is there anything further, commissioners? Commissioner Okuda.
Thank you, Mr. Chair. Mr. Yee, if this matter continues further, if you can also, provide us the Office of Planning's input as far as what would be the best planning decision with respect to use of this property, whether a reversion to an agricultural designation is a better planning decision, or is it better to leave it in the urban district with perhaps modification of conditions, if you can do that. To a large extent also, I kind of echo and agree with Commissioner Chang's concern. And to that end, if you wouldn't mind, if the Office of Planning in fact is going to go and make a more formal presentation on the issue of taking, I'd ask you to go and look at the Bridge Ainalea case. I'm not going to repeat the quote of the paragraph I think I read word for word in the last in two prior proceedings, but the Hawaii Supreme Court seems to have recognized that a boundary designation, change to urban itself has consequences. There's consequences beneficial to the landowner or the applicant in the increase in value just because of the boundary designation. And there's a detriment to the community if representations made by the applicant or developer are not kept. So I'm not really sure if the constitutional taking issue really applies here, because if certain additional conditions are placed, even a performance bond, it's not as if value is being taken away from what the applicant had right before the applicant got the boundary amendment. So I think that's just an issue that needs to be fleshed out. And if you also at some point in time don't mind giving us your input, because we all do value your input and your office's input a lot, about number one, the concern I have that it seems like there are far too many status reports where statements are being made, where material facts are being omitted. And as you probably are aware, there's a Hawaii Supreme Court called AIG versus Bateman, BATEMAN, where the Hawaii Supreme Court said an omission of a material fact to a tribunal, the Supreme Court didn't just limit it to the court. They said a tribunal, a material omission of or an omission of a material fact to a tribunal is the same thing as an affirmative misrepresentation. So if at some point in time you can comment on whether or not the appropriate people or agencies need to take a harder look at status reports that are being submitted to the Land Use Commission, which omit material facts, because perhaps faith in the government might be helped if we make sure everybody who's dealing with the government, and all of us in government also, deal with everything honestly without any omissions. So thank you very much, Mr. Chair. That's basically all the questions I have, to be answered later.
Thank you. Anything for, Mr. Yee, please.
I just briefly, just to be clear, my reply regarding takings to Commissioner Chang's comment was with respect to the imposition of a new condition, presumably against the agreement of the petitioner. So the question was not whether the Land Use Commission would commit a taking if it enforced existing conditions. The question was what I was trying to address was, would there be a takings question if the LUC were to impose a condition that the petitioner was not agreeable to, and then tried and in a particular circumstance. So and I think that is a little different than the case. Thank you.
Mr. Yee, just so you know, your audio kind of cut out a couple times. We got the vast majority of it, but there seems to be a little bit something going on with your connection. Commissioner Ohigashi.
Mr. Yee, are we able to modify the existing DNO regarding this matter to include any type of requirement for a bond?
Well, I guess the question would be, would it be with the agreement of the petitioner? If so, then no one can appeal it. If not, then there could be. I mean, the general question, of course, is can you amend decisions that have already been issued? Technically, yes, but then the devil's in the details about the particular amendment.
And if we were to amend it, would it require us to have a hearing on this matter?
Okay, so there are a variety of issues that will come up if you try to amend a decision order without the agreement of the petitioner, including put aside the takings issue I addressed with Commissioner Chang. The other issue is if you impose additional conditions on land, in which the owner has a vested interest. Are you taking away a right without just compensation? So the case is done, right? And you're finished. And then so many years later, you come back and say, okay, now I want you to also provide a park that was not originally required.
So
could arguably be not a condition a new condition you could impose.
Mr. Yee, it's a simple question. The question I'm trying to get at, or the point I'm trying to get at, is that I don't know if a status hearing and discussion of this matter in regard to whether or not we will move to an OSC would contemplate us being able to, assuming that we go to an OSC hearing, contemplate us being able to amend the document to include a condition, should we decide not to revert, to amend the order to do such a document.
I think that's almost a sunshine question, in which I think if you have so I don't think you can do it today, because the only thing on your agenda is a status conference. But you're coming to this issue again, right, on the order to show cause question. If you added to that, consider an order to show cause or an amendment to the DNO, then you'd look back at your rules. Your rules do allow for amendments at the decision of the Land Use Commission. I have to tell you, there are a lot of different issues that come up in a specific issue.
So before you go into that,
okay.
Yeah, I just wanted to know what and who would be
not today.
And who would be the person that would petition the Land Use Commission to include such an amendment into the DNO?
In your scenario, it would probably be at the motion of the commission itself. I mean, I guess any of the parties could, the petitioner could ask to amend, but presumably they're not. So if you were to amend, it would be at the Land Use Commission's own motion, which then brings up the issues of notice.
And the last question I have is, well, not the last question, but the question that I have is, in such a scenario, who would bear the burden to establish that such a condition can be or should be attached to the DNO?
Because it's at the motion of, in this particular scenario, at the Land Use Commission's own motion, the Land Use Commission would need to find by a preponderance of the evidence that there is a basis for the amendment. And getting into the specifics of what you require to show would need to determine what the specific amendment is.
So the Land Use Commission would have to call its own witnesses to make sure that our decision is supported by the.
I don't know in which the commission has ever amended an order requiring a factual determination. So I suppose the commission could, if it involves state witnesses. I'm sure the Office of Planning would assist you in getting witnesses. But you know, I guess that's what you would have. If you needed a factual showing, I guess that's what you'd have to do. The Land Use Commission is a little limited in its logistical ability to do some of these things because it's not a party, and it really doesn't contemplate that kind of role to be taken. You have authority, but really not a process by which you would pursue these things.
So I'm just
already evident.
Right, Mr. Yi, I'm just was curious about the process about my second comment is under the terms of the existing statute and law, would you say that there has been sufficient showing that there's reason to believe that the property or that the conditions imposed on the DNO would not be complied with or not be performed, and that there is sufficient basis to move to an order to show cause hearing in this matter?
You know, given the fact that your only option is to revert and that the petitioner has asked that the property be reverted, I don't know why you need to go to an order to show cause at all. I think you could just move straight to the reversion.
And I assume that we would have to go into executive session to determine if our own attorney general would agree to that.
Absolutely.
No further question.
Thank you, Commissioner Ohigashi. Commissioner Chang.
Thank you, Mr. Chair. I just want to clarify, because I could see Mr. Welch getting a little anxious, that my comments regarding performance bond is not related to this particular docket. It would be in the context of a brand new DBA. I do not believe that, one, there's a basis to seek a performance bond in this case. And I would agree with you. I don't think that we could, after the fact, after a designation, require a new condition unilaterally without the consent of the petitioner. So I just want to clarify that my comments or questions regarding a performance bond were more hypothetical in the context of a brand new DBA, but not in the context of this particular case.
Thank you, Commissioner Chang, for that clarification. I was wondering as chair whether you were trying to apply these comments to the agenda item at hand or whether to a hypothetical case. Given your clarification, I'd like us to move on and return more strictly to the agendized item before us. Are there any further questions or comments for Mr. Yi and the Office of Planning? Commissioner Axon.
Just one question for Mr. Yi, or I don't know if maybe our AG need to answer this. You mentioned that our only recourse is to revert the property to original designation. How if the commission doesn't do anything on this one and just let it go? Meaning stays agriculture. Since that nothing is really happened, there's no what do you call this substantial
commencement
improvement construction on this one.
If you did nothing, then at a certain point in time, the petitioner will presumably be in violation of the conditions for failing to construct within 10 years from the date of the decision in order. Assuming no one enforces, so neither the county nor the Land Use Commission moves on this matter, then the land stays in its urban and rural classification with its zoning, but an inability to comply with the condition. As a practical matter, this would probably make it difficult to sell the property, as any sale would have to inform the buyer of the existing cloud based upon the violation of the Land Use Commission decision. But it doesn't, I mean, I think that's what would happen. So the land would, it'd be difficult to develop the land, so presumably it would stay fallow. I'm not sure how the county would then deal with any request to use the land for agriculture. I defer to the county on that question.
In case somebody came and miracle happened, somebody is interested, then the petitioner or whoever is gonna take over can file a motion to amend.
They could. So let's take a simple question. If there was a buyer who had said, I buy this property, I'm prepared to develop it, I need 10 more years to develop it. They could approach the owners and say, I'm willing to enter into a conditional sales agreement in which if the LUC amends the decision and order, I will pay this much money to buy the land. I will say, as a practical matter, it's a chicken and egg question. That is, are you going to get a developer who will enter into the due diligence that's required to do this? Because that's still money to determine, right? Whether or not you even want to enter into a conditional sales agreement. Whether you will get the developer before you amend the DNO. So which has to happen first? Do you amend the DNO first to give them 10 more years? Or do you get the developer and then, get it? But there are problems both ways, right? Because on the one hand, you're less likely to get developers if you don't amend it first. On the other hand, if you just amend it, we always have problems with lands that are just sort of laying there, nothing being done and no obligation to do anything. That was the original reason we came up with the 10-year backbone infrastructure requirements 15 years ago. Previously, there was no requirement to construct in any timetable. So you have to pick your poison as to which you'd prefer and what would work for any particular situation.
I don't think it's gonna make a difference because the petitioner saying that they don't intend to do anything about the property. So it's gonna remain fallow no matter what. If that's the client, that's the petitioner's intention is not to do anything on the property.
Was that it, Commissioner Axon?
Yes, thank you.
Thank you. Commissioner Cabral.
Thank you. All of this discussion has brought me right back to what my first thought was when reviewing this information is we've done it already since I've been on the commission where somebody has done nothing, and then we've stepped in and said, you're not in a position to do anything. So we have reverted them back to the ag. So now we've got the exact opposite where the actual, who's evolved and generally in those cases, it was again, some property was in foreclosure and, the reality of life has taken place. I guess one of my thoughts is because I'm in real estate, once you get our designation, does the property taxes suddenly go up from agriculture, which can be very low if you're working the agriculture benefits to your urban or rural tax charges are much higher. That might be a question for Mr. Hopper, but again, thank you, Mr. Yee. My thought was that what you've said is verifying, I think, my understanding, and you verify that. They're asking to revert back to ag for whatever reasons. Otherwise, our option would be to force them to go back to ag at another hearing at another time. So the only question is, as Commissioner Zahn said, is do we want to let them just float in this? But if there's no tax deficit or no consequences to it, then maybe some future buyer. I would think again, if you're in a better value, if you're at a higher and better use potential for the land, the real estate should sell for more. However, it does come with that obligation. And if you can't get water, then I could send some over from Hilo, but until we get that worked out, I don't know whether that land can ever get developed. So so I think my understanding is, I don't know what we're all talking about here. Let's just get practical. They can't afford to do it. Let's let it go. Otherwise we'll get together in another year and we can force them to revert. I don't know. I mean, am I missing something? I guess, Mr. Yee, since you're sort of become our expert on the, on the stand right now.
Just as the person in the hot spot, I think if the petitioner wants to revert the property, our view is let the petitioner revert the property.
That's my feeling. Thank you very much for verifying my common sense, simple point of view. Okay.
Commissioners, is there anything further? Seeing none. Mr. Welch, thank you for your patience on this matter. Do you have any final comments or rebuttal you wish to make?
No, thank you, Chair. This is the first time I've been before this commission, and I've enjoyed the experience because I think the discussion was very good. And thank you for hearing me out on this, and I appreciate your efforts.
You're welcome. And I will say that even if you had appeared in front of the Land Use Commission in previous years, this is, as I'm fond of saying, not your daddy's Land Use Commission. We really engage in issues. Commissioner Ohigashi.
I'm not sure if I'm supposed, when are you going to call for an action or?
Oh, okay, yeah, I'm about to, but I was seeing if there was any final questions for Mr. Welch after he had concluded. Okay, so. Commissioners, we now can enter deliberations on this matter. As a reminder, pursuant to Hawaii Administrative Rules 15-15-93B, quote, whenever the commission shall have reason to believe there has been a failure to perform according to the conditions imposed, or the representations or commitments made by the petitioner, the commission shall issue and serve upon the party or person bound by the conditions, representations, or commitments in order to show cause why the property should not revert back to its former land use classification or be changed to a more appropriate classification, end quote, and set the matter for hearing. I will now entertain a motion, Commissioner Ohigashi.
I move that we set this matter for an OC hearing based upon the statements from Mr. Walsh and the record on file indicating that there's reason to believe that there will be a failure to perform this matter.
Thank you, Commissioner Ohigashi. Commissioner Okuda.
Mr. Chair, I second that motion.
Okay, thank you. Does the move on to the seconder wish to speak to the motion before I open up to general discussion?
I just want to say that I think that Mr. Yee's opinion is a practical one. However, I believe that it is incumbent on Land Use Commission to follow its rules and to make sure that we do the proper thing. And according to our statute, or according to our statute, we would be remiss if we do not pursue this matter through an OSC process.
Commissioner Okuda.
Thank you, Mr. Chair. I agree with what Commissioner Ohigashi has stated as far as our duty to inquire. I believe this situation is distinguishable from the other OSCs we've had, but what I would like to see is additional information from the county and the Office of Planning as far as what they believe would be in the best interest, especially of the residents of the county of Maui, as far as what future use of this property should be. And so I think a further hearing is the appropriate way to have the full and complete record that's necessary. And my questions do not indicate any predisposition one way or the other regarding this matter. Thank you, Mr. Chair.
Thank you, Commissioner Okuda. Is there further discussion on the motion to proceed to an order to show cause? Commissioner Cabral?
Yeah, thank you, Chair. I'm going to support this motion, and I kind of want to take this opportunity because I'm so involved with housing. And of course, really all we asked about was what about affordable housing? What about the obligation on affordable housing? Because affordable housing is clearly the buzzword of the century or the decade here. And yet I see this over and over again, not just with us and what we're doing with the LUC, but also at every level in government and in private business. I mean, no one's worried about what's going to happen to the multi-million-dollar homeowners, you know, without them having another house. But that we need to recognize that I think we need to better look at it. And of course, this all started years ago with a different petitioner and a different landowner in a sense. But everybody, including in a sense, the county of Maui, you know, to say, oh yeah, we'll let all these things happen. But if you know, I mean, the county, you have a housing shortage in this case. Now we're not going to have these affordable housing or any additional housing. I mean, it's supply and demand. If you had tons of housing, all the prices would eventually come down. But that the county needs to understand in this very case, the reason it can't happen and didn't happen before, and obviously is not cost effective to have someone else in the future happen, is there's no water. So what's it going to take? I mean, is it completely impractical, or what is the county doing to try and develop more sources of water? I mean, every year we have the flood and then we have the drought. So what is it going to take in our environment that we can capture that water in some way, shape, or form? What's it going to take to have the infrastructure available to provide that developers can then develop housing that will include affordable housing for our citizens? And I think that this past attitude, just pushing on the developer to have to pay for everything, is clearly not currently cost effective for that developer, and obviously hasn't been in the past. So I just wanted to scold everybody in the system for being part of the problem of why we have not enough affordable housing in our state. That's my soapbox. Thank you.
Thank you for the scolding, Commissioner Cabral. Is there anything further, commissioners? I will vote in favor of the motion. It's the appropriate procedural method that we need to go through, even though I note the comments of Mr. Yee. I'll just say right here, if I may scold for a moment, or at least comment for a moment, I've increasingly reacted to the references from a cultural perspective or an ecological perspective. I've recently been reacting to the references to parcels of land as vacant. That's not a cultural perspective necessarily. A land that is vacant from a sort of capital perspective might be simply lacking or not seeing certain relationships that exist on a property, whether they be ecological or cultural. So I'd like to suggest we start to reframe our thinking about what land is and is not. With that, is there anything further, commissioners? If not, Mr. Ordecker, will you please poll the commission?
Thank you, Mr. Chair. The motion is to proceed to an order to show cause hearing on this matter. Commissioner Ohigashi.
Aye.
Commissioner Okuda.
Yes.
Commissioner Axon.
Aye.
Commissioner Cabral.
Yes.
Commissioner Chang.
Aye.
Commissioner Giovanni.
Aye.
Commissioner Wong.
Aye.
Chair Schreier.
Aye.
Thank you, Mr. Chair. The motion passes with 8 affirmative votes.
Thank you, Mr. Ordenker. So I expect the staff will prepare the order for my signature.
Yes, that is correct, Chair. Just for your knowledge, the motion for order to show cause requires some different noticing of the hearing and some notification in the newspaper, actually, in some different timeframes. But we will prepare the order for your signature.
Thank you. And based on the information today, the commission anticipates hearing the docket on A11-790 order to show cause on June 9th and 10th, 2021. With that, it is now 11:13. We have gone 60 minutes exactly. We will take a recess until, well, let's see. Our next item is the GRIER motion. Yeah, let's take
To 12:30. Chair,
Commissioner Wong.
can we move to go to 12? Take a break till 12:30?
And take our lunch break now.
Yes, please.
Do any of the commissioners have an issue with that, or does the, sorry, Mr. Welch, I know it's from your firm. Are you speaking to the GRIER motion as well?
No, Chair,
sorry.
it's James Geiger.
Okay.
And no, we do not oppose the commission taking a break.
Okay, thank you. Yeah, I thought it was you, Jim, but Mr. Hopper.
Just real quick, Kristen Tarnstrom from our office, I think I had said will be joining for this item. And so she's still listed as an attendee. If it'd be possible to work with staff to have her as a participant or get.
Absolutely, we will promote her, such as it is.
Thank you.
Many would consider it a demotion, but I will consider it a promotion. With that, let's recess until 12:30. Was that the request, Mr. Wong?
Yes, Chair.
Oh, banker's lunch hours today. Okay. 12:30, and we will resume our proceedings then. Thank you very much, Mr. Welch. Thank you to all the parties on this last matter, and we will recess until 12:30. Started. Our next agenda item is docket number DR 2171, Andrew GRIER, Maui, a petition for a declaratory order that the number of dwellings allowed on properties in the rural district can be more than 1 per 1/2 acre if allowed by county zoning. Will the petitioner please identify yourself for the record?
Good afternoon, Chair, Commissioners. My name is James Geiger. I am the attorney for Andrew GRIER. Andrew is also present with me, although you cannot see him on camera.
Okay, thank you. I'll note we continue to have with us representatives from the County of Maui and the Office of Planning.
Good afternoon, Chair. This is Kristen Tarnstrom. I'm the Deputy Corporation Counsel that's working with the Department of Planning on this. And I physically have the Director, Michelle McLean, with me, who you will see off and on as she moves in and out of the break.
Okay, thank you. And Mr. Yee.
Good afternoon, Deputy Attorney General Brian Yee on behalf of the Office of Planning. With me is Ronnie Funakoshi and Aaron Sedagawa from the Office of Planning.
Okay. And I'll just note that technically in matters of declaratory orders, the petitioner is actually the only true party, but we will allow for public testimony by the County of Maui and the Office of Planning. And I will also intend to, as I will describe later, offer them a chance to provide further testimony towards the ends of our proceedings. So before we begin, however, let me update the record. On February 11th, 2021, the Commission received the petition for the declaratory order, Exhibits A and B, a verification of Andrew GRIER, a certificate of service, and the $1,000 filing fee. On February 26th, the Commission received DR 2171, County of Maui's Departments of Planning's response, their appendices A through D. On April 1st, the Commission emailed the meeting agenda for the April 14th and 15th, 2021 dockets to the parties and the statewide and county mailing lists. On April 5th, we again on the 1st, we emailed the meeting agenda. On the 5th, we mailed the agenda to the parties in the docket and our statewide and county mailing lists. And on April 6th, the Commission received the Office of Planning's response to the petition for the declaratory order, as well as the respondent Department of Planning, County of Maui's response to the petition for declaratory order. Let me now go over our procedures today. I will first give the petitioner the opportunity to comment on the Commission's policy regarding reimbursement of hearing expenses. I will then recognize any written testimony that's been provided. Following that, I will provide the opportunity for any interested members of the public who are attending this meeting to provide oral testimony in the manner that I've previously described, bringing them into this meeting and swearing them in. If anybody is attending by phone, they should press *9 to raise their hand virtually, otherwise use the raise their hand function in the software for the Zoom webinar platform. Following the completion of any public testimony, I will call on the county and state to provide testimony on this docket. And followed by that, I will allow the petitioner to make their presentation. Following the petitioner's presentation, we'll hear any questions or comments from the commissioners. And if there is additional time available, I will allow additional time for the county and the Office of Planning to provide testimony. Finally, based on the information received today, the Commission will determine further action. Mr. Geiger, are there any questions with our procedures for today?
Just to be clear, you do not wish to hear from me until after the public testimony is closed, correct? Other than the fee and cost issue.
Well, I'm going to keep the public testimony open for the purposes of continuing to hear from the Office of Planning in the County of Maui.
Okay. So I guess you want to hear from me before they talk, correct?
To be clear, I'm going to ask, so in declaratory rulings, technically there is only one party.
Correct.
However, due to the very integral nature of the Office of Planning in the counties, in the respective counties, to our proceedings, I'm going to offer them the opportunity to provide public testimony on this matter. Then we will hear from you. And I will also provide an additional opportunity to them to comment after you've presented, to which you may choose to rebut. Is that clear?
Thank you. Thank you.
Okay. And Mr. Geiger, have you reviewed HAR 151545.1 with regard to the reimbursement of hearing expenses? And if so, what is your position?
Yes, we have a weed waive reimbursement.
Okay, thank you very much. Mr. Hakoda, is there any written public testimony that's been submitted on this matter since it's been agendized?
This is Scott Derrickson.
Oh, Mr. Derrickson.
No public testimony on this matter has come in.
Okay. Are any of the attendees who are attending this meeting wishing to provide public testimony on this matter? If so, use the raise your hand function. Seeing none, there's no general members of the public wishing to provide public testimony. I would like to now actually hear from the county, followed by the Office of Planning, and then we'll under public testimony, and then we'll hear from the petitioner. County of Maui.
Thank you, Chair. The County of Maui has submitted a full response in writing to the petitioner, and we mainly rely on that submission for the Commission's consideration. But I would just like to add, our position is generally speaking that if we're applying this law incorrectly, we just want to know, which is part of why we fully support the Commission deciding this matter. So they can provide clarification for the department going forward. We don't believe we've been applying it wrong, obviously. This case is truly about the confluence of 46.4C and 205 Hawaii revised statutes. And it very much turns on your interpretation of 46.4C. And that statute is a general statute. It applies to all counties, it applies to all districts, and it applies in all circumstances where a dwelling is already allowed on a lot. Where a dwelling is already allowed, the county is allowed to make specific rules and regulations to allow 2 dwellings on that lot. It's basically, where one exists, the county is empowered to allow there to be 2 under certain circumstances. And that's the nature of Ohana zoning in and of itself, to provide a dwelling unit with an Ohana unit. Where more than one dwelling is already allowed, 46.4C simply has limited utility, if any utility, as it applies to the number of dwelling units allowed. So on petitioner's 2-acre lot, or approximately 2-acre lot, he's already allowed to have multiple dwellings. He's already allowed to have 4 under the state statutes. And in that case, Ohana zoning and the 46.4C simply doesn't apply because there's more than one dwelling unit already allowed. And what 46.4C allows is the county to make one dwelling unit essentially into 2. That is supported, as we fully briefed, by the context of the statute, the legislative history, as well as the plain language of that statute. Petitioner reads 46.4C quite differently. They essentially argue that the county can allow as many additional dwelling units as is reasonable on a lot. In order to get to that point, you have to rewrite the statute. You would have to change the very specific wording that it's 2 dwelling units, and you would have to change that into a reasonable number of dwelling units and make other changes to the statute. Additionally, if you adopted this interpretation, it would be abrogating all of the density requirements for rural zoning that are considered under the state statutes. All of this is under the state level zoning, which has to direct how far the county is allowed to go in its own zoning. At the county level, as we briefed, the should it not have been state rural, or there was a different say it was state urban, and it was just the county density requirements that were considered, petitioner would be allowed to have 6 dwelling units. They would be allowed to have 4 single family and then 2 accessory units. But that isn't the case here. 205 is relevant. It does limit the number of dwelling units that are allowed on this, and county zoning is not actually very relevant in this case. Also, just generally speaking, the state has its own land use requirements and regulations, and the county has its own land use requirements and regulations. And as the Office of Planning pointed out in their brief, the county is limited and it cannot expand upon what's expressly set forth in the state statutes. And it doesn't. It fully adopts the limitations provided in the state statutes in its own, in the county code. I intended to stop there and can take questions whenever is appropriate after the petitioner is gone, or now if that is the chair's prerogative.
Yeah, I'd like, normally our procedure, Ms. Tarnstrom, is after public testimony, which this is falling under, you'll be available for questioning from the commissioners. So,
thank you.
You're ready for that?
Yes.
Okay. Commissioners, questions for the county? Commissioner Okuda?
Thank you, Mr. Chair. And I thought I promised some people I would try to keep my mouth shut. Let me just ask a question on the standard and procedure that we are to apply in deciding this case. And my question deals with whether or not, similar to the short-term vacation rental issue that we faced with a County of Hawai'i ordinance, whether this standard of looking at both the state and county requirements have to be looked at, and the Land Use Commission has to adopt or follow, or actually what everybody should follow is the more stricter standard law or ordinance. What I'd like to do first is just to read a very short paragraph from the Hawaii Supreme Court case, Save Sunset Beach Coalition versus City and County of Honolulu. That's found at 102 Hawaii 465 at page 482. The Pacific Third citation is 78 Pacific Third, page 1 at page 18. That's a 2003 Hawaii Supreme Court case. What I plan to do, if it's okay with you, is I'd like to read that paragraph. After I finish reading the paragraph, I will ask you whether that's an accurate statement of the law. And then number 3, after that, whether or not that rule is, or that statement of law is applicable to how we should evaluate this case. And frankly, I'm going to ask the same question to the other parties also. So let me start reading the paragraph. Quote, in Hawaii's land use system, the legislature's statutory districts constitute more of a general scheme, and presumably by delegating authority to zone to the counties, the legislature intended that specific zoning be enacted at the county level. We believe that the, quote, consistency doctrine, close quote, enunciated in GATRI, G-A-T-R-I, is somewhat instructive in the instant case. Because the uses allowed in country zoning are prohibited from conflicting with the uses allowed in a state agricultural district, only a more restricted use as between the two is authorized. By adopting a dual land use designation approach, the legislature envisioned that the counties would enact zoning ordinances that were somewhat different from, but not inconsistent with the statutes, close quote. So my question is, do you agree that that is an accurate statement of the law?
Thank you, Commissioner Okuda. Yes, we do agree that that's an accurate statement of the law.
And is that the standard that, one of the standards we must apply in this case?
Yes, we believe so.
And so if you looked at the County of Maui's ordinance in total, as you have described it, and let's say the petitioner's interpretation of how or what the state land use law says, which would be more restrictive?
In this instance, given these set of circumstances where the property is zoned county rural 0.5 and state rural, the state statutes are more restrictive than the county statutes at this under this circumstance.
And I'm going to ask also this question to all parties. And if you don't know, you can just say you don't know or you're not aware of it. But I'm going to ask the same question to the other parties. Can you point to anything in Chapter 205 or anywhere else in the Hawaii Revised Statutes which gives the Land Use Commission subject matter jurisdiction to determine the scope and effect of a county statute, a county ordinance, or county policy?
I'm not aware that that exists. I don't think it's required in this case to interpret the county ordinances, but I don't believe that that would exist.
Okay, thank you very much, Mr. Chair. Thank you. I have no further questions.
Thank you very much, Commissioner Okuda. Commissioner Ohigashi, I see a virtual hand and I do not see you. Ah, there we go.
One of the problems I have in this case is that this is one lot, but condominiumized into 4 separate condominiums, I understand. My question is this: if there was a subdivision and each lot was 5.5 acres, how many structures or how many houses would the county allow?
I can have the director confirm this. This is a bit of a word problem for me, but I believe that under this circumstance with 2 acres subdivided into half acres, the applicant or whomever owned that land, each half acre would be allowed a dwelling unit, as well as I'm not sure what that square footage is, but they would be allowed an accessory dwelling according to the county codes and statutes. Limited, actually, they'd be allowed 1 accessory dwelling. So each of those lots in this instance would be a total of 8, I suppose. There.
Now, the next question I have is in regard to that. Does the county view a condominium as a subdivision?
No, we do not consider a condominiumization. Sorry, I just brutalized that. We don't consider that a subdivision. It is still 1 lot as far as the county is concerned. And that's how we view it in terms of land use.
And the last question I have is this, is that I noticed in your filings and in the petitioner's filings, a comment that if property is under 7,500 square feet or above 7,500 square feet, that they would be permitted, or less than an acre, they would be permitted 2 dwelling units on that. In other words, a regular home and an accessory.
Yeah, that's the county code that you're referencing?
Yes.
Yes. Under county rural zoning, it allows 1 house per half acre with accessory units as provided by the code. The code and chapter 205. So
Is that more restrictive or less restrictive than the requirements in 205?
The county ordinance adopts 205 and accepts its limitations if they apply, and the county code itself, if the 205 weren't in place, the county code, yes, would allow 2 accessory units and 4 dwellings on this property. I hope that answers your question, if I understood.
Well, let me ask it this way then. Let's say it was subdivided into 3 lots, each containing, I guess that would be about 3/4 of an acre, right? About 0.6 of it, 0.6 something of an acre. And on each of those lots, how many dwellings would be allowed?
Under this circumstance where you have state rural and county rural, you would be allowed 1 dwelling home and 1 accessory unit.
Is that more restrictive or less restrictive than the state?
That is, if it was subdivided, I think that is, I think it's the same, because the state and county codes are both applying in that circumstance.
If I could add, Commissioner Ohigashi, when we talk about what the state requirement is or how restrictive state law is, we're looking at 205, which says a density of 1 home per half acre in state rural. But we also have to be mindful of HRS 46-4, which says you have to allow 2 dwellings where a dwelling is allowed. So while 205 is more restrictive and only 1 dwelling, HRS 46-4 says we have to allow the 2, and that's what county zoning allows.
If I may, Ms. McLean, I think technically I need to swear you in.
I apologize, Chair.
You swear affirm the testimony you just gave is the truth?
Yes,
and
I
what
do.
you might give in the future? Okay, thank you.
Yes, I do.
Please continue, Mr. Ohigashi.
Does 46-4C mandate 2 dwellings on each property? Or does it create a procedure where the county can legislate having 2 dwellings?
The 46-4C gives the county the power to adopt reasonable standards to allow 2 dwellings.
So I'm going to take the planning director's statement as being her impression of what it was rather than what the law says. Is that right? In other words, it doesn't mandate 2 dwellings. 46C does not mandate 2 dwellings.
Thank you for the correction, Commissioner Higashi.
All right, so that's all I have.
Okay. Commissioner Chang.
Thank you, Mr. Chair. I just have some factual confirmation from the county. One, the petitioner came in and applied for a building permit for the 4th dwelling, and the petition and the county subsequently denied that. Is that correct?
Well, thank you, Commissioner. I believe the facts, and Mr. Geiger obviously can comment on this in his presentation, but I believe the facts show that it was really the 5th and 6th building permits that were initially reviewed as acceptable by the planning department when it was asked to review them by the Public Works Department. But upon further review, planning, before they were ultimately granted, planning realized its error and informed Public Works that it was not consistent with zoning those 2 building permit applications.
Okay, so it was the 5th and 6th. And do you recall who the petitioner, who the applicant was for those 5th and 6th building permits?
That's not part of the record that was submitted, but I believe Mr. GRIER can discuss that. It's my understanding that the petitioner himself submitted all building permits. And if I may, I actually remember now, it was the 4th and 5th building permit, I think, that he requested. He was granted the 4th, and then the 5th was withdrawn, I think. But I'm gonna rely on Jim's representation for that.
Okay, and I'll ask him to clarify that as well. And upon the denial of the permit, the fifth dwelling, did the petitioner file an appeal with the circuit court?
Again, not part of the record so far, but from my understanding, that hasn't received final review. So it hasn't fully been decided yet. It is still pending final review at this time.
Wait, I'm sorry, what is pending final review?
That would mean that the Public Works Department, who processes these applications, is still reviewing the application, but they have gotten planning's comments on it, but they still haven't issued a final decision. And from what I understand, that could be appealed to the BVA.
I see. So there is still, the county has not finalized its determination on that building permit, but the petitioner has come before LUC on the basis or the assumption that the county is going to deny that permit. Is that correct?
You'd have to ask the petitioner that exactly. That is, I think that's technically true. However, that I think there's still a conflict between the department and the petitioner that satisfies the requirements to seek a decision from this board.
Okay, so it may not be right to go to the courts, but the petitioner is coming before the Land Use Commission.
I'm not certain about ripeness. I think that there is a conflict between our interpretations, and I think that this body, it was our position that this body would we'd benefit from having an opinion from the Land Use Commission on the interpretation of these statutes, and I think the Circuit Court would benefit from that as well upon review of this decision. So I'm not certain if it's ripe or not.
But there's been no final decision made by the county.
I think it's fair to say there's been a final decision on the application of these statutes, but there has not been a final decision by the Public Works Department on whether or not on the status of the applications of those building permits.
Okay, it's not really clear in my mind how that distinction, because for purposes of, could the county change its determination since no final decision has been rendered on the application?
The director has just reminded me that there's other grounds potentially that the building permits may be denied upon. But in terms of the ripeness question about whether or not the denial was correct, they, yes, could appeal that. I think you raise a good question. I do think the planning department has a final position on this and has issued it in its form of the comments on the building permit application. But yeah, there is no final decision on the building permit.
Okay, all right, thank you very much.
Thank you, Commissioner Chang. Commissioners, are there further questions for the county on their testimony? Seeing none, let's hear from the Office of Planning. Mr. Yee.
Actually, with respect, we'd like to defer our comments until after the presentation of the petitioner. With respect to the question, though, by Commissioner Kula, we will just let him know, since he said he was going to ask all of the parties. We agree with the responses from the county.
Are there any questions from the commissioners for Mr. Yee at this time? Commissioner Kuda.
Thank you very much, Mr. Chair. Mr. Yee, do you have any comment to Commissioner Chang's question about the doctrine of exhaustion of administrative remedies, which basically is you got to finish off your fight in the agency or that chain that you're dealing with before you go somewhere else to bring an appeal or to challenge it? I mean, I'm just really roughly defining that.
I would address it a little differently, and I don't have the rules out in front of me, but I believe in declaratory petitions, the commission is allowed to refuse to take up a declaratory petition if it believes it's the subject of a pending court or administrative action. So if you may choose not to answer the question, not because of a finality issue, simply because the Land Use Commission has the discretion not to get involved in issuing decisions that are the subject of other proceedings. So I don't know the finality issue is quite the same, but it's a similar concept.
Is the standard to be applied regarding the doctrine of exhaustion of administrative remedies, is the standard that's applied in a court of law the same as the standard that's to be applied by an administrative agency like the Land Use Commission?
I don't think that there is specifically an exhaustion of remedies requirement because it is a discretionary choice by the Land Use Commission. It really goes more to the question of whether the Land Use Commission wants to take up the question rather than an obligation that would prevent the Land Use Commission from taking something up if it wanted to do so. So
well,
there is a difference.
Yeah, well, my final question is it appropriate for us to look at case law regarding the rule regarding of exhaustion of administrative remedies as applied in court to decide whether we should exercise discretion, whether to take up this issue or not take up this issue? Or should we avoid looking at the rules that apply in court because that's a different situation?
I would say if the Land Use Commission wanted to use those cases as instructive, I think that's perfectly fine. I think to the extent the Land Use Commission views those cases as being obligatory upon them, I think that would be an incorrect statement.
Okay, thank you very much. Thank you, Mr. Chair.
Thank you, Commissioner Ohigashi. Commissioner Chang.
Yes, thank you, Commissioner Kuda. Though, Mr. Yee, that is sort of my issue here is there's been no final decision. We're being asked essentially to render an advisory opinion or declaratory action, but on a set of facts that may change. And shouldn't we be cautious in exercising that kind of discretion when the set of facts before us may not be final, as well as the petitioner may have other remedies in court, as opposed to coming to the Land Use Commission to answer the declaratory action?
And you may want to ask the petitioner this, but let me, a response might be that this declaratory petition, although based upon a set of facts that are currently before the Maui County, is not dependent upon those facts. That is, he is asking for an explanation of the law and how the law applies more generally to counties. So it could be argued that this is simply a request for an interpretation of state law. And in fact, you don't even need to look at any particular county law for its determination as how it would necessarily be applied in any one, including his particular case. So you're not asked to say how many units are specifically allowed on his 2-acre lot, or whether or not the county ordinances, how those are to be interpreted or not. They're simply asking, could a county allow for more than one dwelling unit on a half-acre lot in the rural district. And that is not necessarily dependent on a particular set of facts.
But shouldn't the Land Use Commission be cautious about interpreting a set of facts that, or interpreting the statute when, they're, I mean, my fear is rendering this sort of this advisory opinion all the time on interpretation. And it concerns me that we are being asked to do that based upon that kind of explanation.
I think you're right to be cautious. I think whether or not you decide to proceed or not may depend upon whether or not different facts require different results. So if there's just a clear, simple legal response, I don't think it's necessarily a problem in issuing a declaratory ruling. Where that declaratory ruling will change depending on the particular facts of the case, then I think you're right. It's more important to to either require the specific facts be brought out and to rule only on those specific facts, or to decline to provide an interpretation. So it depends on the particular matter before you.
Thank you, Mr. Yee. I have no further questions.
Thank you, Commissioner Chang. Commissioner Okuda.
Thank you, Mr. Chair. Mr. Yee, as a follow-up to Commissioner Chang's questions, what is your response to this situation? Let's assume that the state law and the county ordinance are equivalent. In other words, one is not stricter than the other, but the county's interpretation and enforcement of its ordinance is stricter than state law. In other words, the county's actions are stricter than the requirement of state law. Are we required then under the Save Sunset Beach case to defer to the county's interpretation of their ordinance because their conduct is stricter than state law?
I think there are several different issues in that question. On the one hand, you're right, under Save Sunset Beach, the more restrictive requirement applies. Two, I think the Land Use Commission's authority, as you indicated previously, extends to state law, not to county law. So the Land Use Commission would not interpret county law. That's not within your purview or jurisdiction. So if you had a circumstance in which you had two identical requirements, one in state statute, the other in county ordinance, Land Use Commission could interpret that state statute, but not interpret the identical county ordinance, and I think does not necessarily need to rule on whether or not the county ordinance, county interpretation is or isn't correct, because that's not within your jurisdiction. You could only be asked to rule on the meaning and interpretation of the state statute. So with that in mind, you then get to the question of, and so should you rule if there is a more restrictive county interpretation? And then you get into the discussion that I had with Commissioner Chang as to under what circumstances do you issue decisions as a declaratory petition. So I think you would have the jurisdiction to rule on the interpretation of the state statute and only the state statute, but whether or not you decide to exercise that, that authority would be up to you and dependent on a number of circumstances. You could, for example, simply say, here's our interpretation of the state statute. We express no decision and defer to the counties in the interpretation of the county statute. Or you could say, the county has already determined that the county statute means this. We're not going to second guess it, and therefore the interpretation of this, whether there's whether there's a less restrictive requirement under state statute is moot, and so we're not going to take up the case at all. Those are two different results you can obtain from the same facts.
Or would we be clearly erroneous to use the phrase that the appellate court might take in trying to slap us down if we chose a third alternative, which is along the lines of what Commissioner Chang was questioning about, which is right now to really make the determinations that you, Mr. Yee, have gone over, we really should wait to see what the final appealable or final unappealed judgment or final judgment after appeal is, when all of the procedures that are taking place before the county have been sorted out and it's really final, so we know exactly the question that we're called to rule on. I mean, would that wouldn't be clearly erroneous where the Supreme Court would slap us down and reverse us that, you know, we've exceeded our authority or done something stupid, right?
It seems unlikely. The Office of Planning has always been protective of the LUC's discretion, even where we disagree with the ultimate decision. So is it clearly erroneous? The Office of Planning would argue no, that it's within the LUC's discretion.
Right, to basically say that this is something that belongs at the county level, and if somebody is aggrieved, either the county or the applicant, they should take it up with the court, the judiciary, circuit court, through an agency appeal, maybe the Intermediate Court of Appeals, maybe a petition of certiorari to the Supreme Court, and then come back to us when all of that is sorted out.
Well, I don't know, but I agree with you all the way till the end, because at that point, I don't know that there's anything to come back to. In other words, if they argued it and went all the way up to the Supreme Court, they should have argued the issue of the interpretation of the state statute. That was a necessary element to their case. And so they should not, at that point, come back to the LUC after they've had their appellate appeals done.
So in fact, actually, the more, if our interest is in judicial economy or just doing this in an efficient way, it may be better just to leave it down through the administrative process, the Chapter 91 or 92 appeals, and there's just one chain of litigation, not two.
That's the concept behind the provision in your rules that the LUC may not take up matters that are the matter of other proceedings.
Okay, thank you very much, Mr. Yee. I appreciate very much your thoughtfulness in this case. Thank you, Mr. Chair.
Thank you. Commissioners, further questions for Mr. Yee? If not, Mr. Geiger, let's hear from you.
Thank you very much. And again, thank you, commissioners. There have been some very interesting questions that have been asked. And so it's going to change a little bit on how I was going to give my presentation here today. I think I want to focus initially on the issue that was raised by Commissioner Okuda earlier on. I think it's important to note that the commission is tasked to interpret Chapter 205. Commission is not tasked to interpret Chapter 46. The commission has jurisdiction over 205. The counties and state court have jurisdiction over 46. What the county has done, or what we asked for, was a very specific and very general question. The question was, does Chapter 205 limit the county's ability to allow Ohana zoning in the rural district? That was the question we asked, nothing more. The county has come back in and said, no, you have to interpret Chapter 46 with that. We disagree. We think that that is a more specific question, which then gets beyond the jurisdiction of the Land Use Commission. Why do we say that? Well, for two reasons. If you look at 205.5a, the very first part of that statute provides, except as provided herein, the powers granted to the counties under Section 46-4 shall govern the zoning within the districts. That is a clear statement to you as commissioners that you do not respond, you do not interpret 46-4. That is for the counties to interpret. The second clear statement is in the legislative history of 2052C. The important language that we're all focusing on here, or that was focused on here, was the addition in 1989 in 2052C of the following phrase: except as provided by county ordinance pursuant to 46(4)C. The reference was to allow one dwelling unit per half acre, except as allowed under 46(4)C. If you look at Act 5, which is attached as Appendix C to the county's position statement, you will see that the first section of Act 5, the 1989 amendment, states very clearly the purpose of that amendment. And the only thing that was amended in that act was the addition of the language, except for as provided by county ordinance pursuant to 46(4)C. What did the legislature tell all of us? The legislature said the intent of the legislature was that Ohana zoning remain an option for Hawaii's people. An unforeseen and undesired effect of the 1988 amendment, which was to Chapter 46C, was that the Ohana zoning was arguably prohibited by sections 2052 and 2055 in the rural district lands. That's precisely what we're talking about here: Ohana zoning in the rural district lands. The legislature and the purpose went on to state, as the law now stands, even if any county were to adopt reasonable standards allowing Ohana zoning as mandated in section 46(4)C, sections 2052 and 2055 would still supersede those standards and prohibit Ohana zoning. That's precisely what the county is arguing to you here today. They're arguing that 46(4) tells you that they can only have Ohana zoning on rural properties that are a half an acre or less. That is clearly not what the statute says. And the legislative intent was very clear. In fact, the legislature finished up by stating this: the effect is manifestly contrary to legislative intent and is therefore corrected by this act. It is telling you that by the addition of the except as provided for, the Land Use Commission doesn't weigh in on what the county chooses to do. That is uniquely the subject of a different jurisdiction, a different venue. Now, there is some confusion out here as to why administrative remedies weren't exhausted or why we're here as opposed to somewhere else. Well, I hope I can clean it up a little bit. Number one, we'd have no right to seek a review until there's a final determination on the building permits. There has been no final determination on the building permits. Number two, because there was no final determination on the building permits, we filed a declaratory action before the circuit court, asking the circuit court to weigh in and tell us, what does 46(4)C really mean? Which is uniquely where the jurisdiction lies, because that is a county zoning ordinance. That is the ordinance, or the statute rather, that provides jurisdiction, the authority to the counties to act. It's not the Land Use Commission. And as the legislature made clear in the 1989 amendment, that really isn't where you folks should be going. So that's why our declaratory action here is just a very general, very, very general, very specific declaratory request. We are saying that 205 allows the counties to give you a more dense zoning in the rural district if they adopt reasonable statutes. We're not asking you guys to determine whether it's reasonable. We're not asking you guys to tell us how many units we can build. All we're asking you guys to do is to say, yes, 205 says that the county can make a more dense determination or it can have more dense housing in the rural district. The there was an additional argument the State Office of Planning made, and I'm glad they brought it up, which I want to address. They argued and pointed out that the Administrative Rule 15-1563 provided that the counties could impose additional restrictions to lower density or to further restrict uses within the rural district. And in general, that is a reasonable proposition consistent with Save Sunset Beach, Sandy Beach. Save Sunset Beach Coalition, I apologize. But there's a difference here. And again, the difference is in the amendment that the legislature adopted in 1989 to 205-2C, because they were very specific in what the purpose of that amendment was. And again, the purpose of that amendment was not to limit the county's ability to restrict density, but rather to expand the county's ability to increase density. You know, earlier cases here today, you folks comment on how housing is important. We agree, housing is incredibly important. But if you adopt the position of the county in this case, you're restricting rather than increasing housing opportunities. And I would submit to you that while you might have the ability to do it in other cases, in this particular situation, based upon what the legislature did in 1989, you do not have that ability. Finally, just for Commissioner Chang's information, the building permit applications that are pending are for the 4th dwelling and 1 accessory dwelling. Just so you're clear, and yes, they initially were passed, and then the planning department came out and rescinded the approval previously given. But because there was not a final decision on the building permit, we could not appeal that rescission. For Mr. Oigashi, just to be clear for the record, this happens to be a 5-unit condominium project instead of 4. I don't think it makes any difference, but just for the record so that it's clear. And with that, if there are any questions, I'll be happy to answer.
Thank you, Mr. Geiger. Commissioners.
Chair.
Yes, Commissioner Wong.
Thank you, Chair. Good afternoon, Mr. Geiger.
Good afternoon.
You know, in my other life, in my other job, other hat that I wear, I'm supposedly a lobbyist. So I have to keep track of a lot of bills, House and Senate bills. One of the bills that is going around the House right now is HB 502, House Draft 2, Senate Draft 2. The title is relating to rural districts. Do you know anything about this, sir?
No, I do not.
Okay, so if with your indulgence, let me read this to you. It's dealing with section 205-2 Hawaii Revised Statute is as amended as follows. By amending section A to read, there shall be 4 major land use districts in which all lands in the state of Hawaii shall be placed urban, rural, agricultural, and conservation. The Land Use Commission shall group contiguous land areas suitable for inclusion in one of these 4 major districts. The commission shall set standards for determining the boundaries for each district, provided that, blah, 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 okay? I'm going to section C, which is a little bit more of what we were talking about and what you were talking about. They're amending section C to say this: rural districts shall include activities or uses as characterized by low density residential lots of not more than 1 dwelling house per, and they're erasing the 1/2 acre to 1/4 acre. They're changing it to 1/4 acre. So, and provided that each dwelling house shall be consistent with the county general plan and community development plans. Okay, so it appears as that 205C, which you were talking about, they're changing it to 1/4 acre instead of 1/2. Okay, so why would the legislature change this to 1/4 acre while your interpretation was a little bit different? So I think there's some sort of conflict here. So could you explain that to me, please?
Well, again, I have not seen the draft, but if, based upon what you read, it sounds like the legislature is also taking out the language that we're talking about here, which is except as provided by county ordinance pursuant to section 46(4)C. And they're changing it to 1 per 1/4 acre, which means to increase the density, which I presume means to increase housing. If that in fact passes, the decision you folks make may be simply moot. It's not gonna, it's gonna change the entire game.
Yeah, so it seems like right now, this is my opinion, but because of this issue at the state capitol, that, you know, it hasn't come to bear, this DR, you know, in terms of should we even deal with it until we know what's happening with the state level, the legislature level. I mean, that's an opinion of mine right now, because we have to see what the state, it's going through the process, and it appears like it's going to conference, and then it's going to more than likely, it's going to go to the governor for signature. So what I'm trying to say is, I'm thinking, should we even act on this, or should we just hold off? I'm questioning this right now. That's what I'm trying to say, Mr. Geiger. I don't know if I made it clear.
Do you wish comment?
Sure, please.
Okay. Yes, you made it very clear, and I understand exactly what you're saying. And I can certainly understand why the commission would feel it prudent to defer action, because as Commissioner Chang pointed out, you don't want to get out and make basically advisory opinions on something that may have absolutely no impact in the future. However, having said that, I'm not sure it's going to resolve this particular dispute we have with the county, because I believe that will be, again, a dispute concerning the county's ordinance and 46(4)C, which we will be taking up in circuit court as opposed to before you.
So the question is, if you are going to take it to court, I mean, why should we even talk about it? I mean, that's my feeling. I mean, we should let it go through the court system for them to interpret it.
Well, if I may, yes. We did file a declaratory action in the circuit court, Second Circuit, on this. The county indicated that they strongly believed that the Land Use Commission's interpretation would assist the circuit court. It seemed prudent to go ahead and get your interpretation. At the time, the circuit court proceeding has stayed until May 15th, or approximately May 15th, when we anticipated we'd be going back to the circuit court.
Mm-hmm. Yeah, it's just that again, using my other hat, sine die is April 26th, I believe. So, all these things are pretty much moving to some sort of resolution by itself. So I'm just, in my mind is like, should we even work on it? What if, the ledge says, you know what? We'll move it to a 1/4 acre, then everything is moot to me, right?
It certainly makes the issue before you moot.
Yeah, okay, that's it. Thank you, Mr. Geiger. Thank you, Chair.
Okay. I recognize that both Commissioner Chang and Commissioner Okuda would like to ask questions, but we've been going a full hour. I'd like to call for a 10-minute break. It is 1:30. We will reconvene at 1:40. Commissioners.
I'm trying to not be late today.
Nancy, gold star. You've been
So
on time
far.
for everyone.
So far.
Appreciate it very much.
No, I know, I apologize. It's just I should never leave the chair, you know, when you've got 26 employees talking to you, it's hard to run
Yes.
away, you know.
Appreciate
So,
it. Okay, it's 1:41. We're back on the record. Commissioner Chang, questions for the petitioner, followed by Commissioner Okuda.
Thank you, Mr. Chair, and thank you, Mr. Geiger. You did clarify one question I had regarding the status of the deck action filed in circuit court. So it was an agreement between the county and your clients to stay the proceedings in circuit court pending declaratory action before the Land Use Commission. Is that correct?
Yes.
Okay. Were there any other parties to that action?
No.
Okay. And I appreciate Commissioner Wong's bringing to our attention that pending bill. How fortuitous, right? But wouldn't you agree that it may be in your client's best interest, one, not to have a ruling by LUC at this point in time, and maybe not even to have a ruling by the circuit court pending the outcome of this proposed legislation? I would suspect there would be a timing issue. You may have to withdraw your building permit application, because I'm assuming you would fall under the old statute. And so if you wanted, assuming that the bill passes and appropriate changes are made to the law, you may get a better outcome waiting for that, this pending legislation to pass. And I guess that's just me speaking out loud, but wouldn't you agree that it may be in your client's best interest to at least wait until after the outcome of this legislation to seek a final decision by either LUC or the circuit court?
Well, two things. Number one, I have not seen the legislation, so I don't know exactly what it says or whether there's any other provisions to it. Number two, it's really up to the commission as to whether it chooses to act or not. We've brought this to you requesting a determination of the law as it exists today.
Right.
If the law changes, then you've issued a ruling which will have effectively no application. So it may actually be to the commission's interest to defer action more so than to my client.
Or it could be in the interest of those other landowners whose county's interpretation, who the county, based upon their interpretation, acted accordingly. Because if in some way our interpretation is contrary to the county's interpretation, then doesn't that potentially put at risk all of the county decisions based upon that determination?
I don't think it puts at risk prior decisions. I think it may have impact on the future. But again, we're here on a general question, not specific to my client's property. We are here on a general question that I think the commission could answer. But as Commissioner Wong has pointed out, if there's new legislation that passes, it may make this answer meaningless for everyone.
And I think you would appreciate sort of my general, you know, most administrative and judicial bodies would prefer to take an action that's been fully developed, the record is clear, rather than rendering advisory opinions. Wouldn't you agree with that as well?
I do, but as Mr. E pointed out, this really isn't as much an advisory opinion as it is a request for an interpretation of existing law.
Okay. All right. Thank you very much, Mr. Geiger. I have no further questions.
Thank you.
Thank you, Commissioner Chang. Commissioner Okuya, followed by Commissioner Cabral.
Thank you very much, Mr. Chair. Thank you very much, Mr. Geiger, for being present here. I'm glad the chair said we don't have to disclose relationships with witnesses. I know you and I do not have any business or social relationships. I think our only connection is we are dinosaurs, just like Commissioner Ohigashi, and remember practicing law on Maui in the old courthouse before Ho'opili Hali was built. But getting back to business here and not reminiscing about the old days when dinosaurs roamed the earth. I read that quotation from the case Save Sunset Beach Coalition versus City and County of Honolulu. Do you agree that what I read is an accurate statement of the law? Without getting into whether or not that statement applies, that would be my next question. But do you at least agree that what I read is an accurate statement of the law?
You accurately read the case. I do disagree that the case has applicability under the facts before us, but you accurately read the case.
Okay, can you please tell us why you believe the case is not applicable to the matter we have before us?
Because again, it relates to the legislative history that was specifically stated with regard to the language that is being reviewed, the except for as provided in 46C4. If the legislature had not been so clear in saying that the purpose of the amendment was to allow the counties to adopt reasonable zoning ordinances concerning the rural district, then I would have been exactly with you and said, yes, Commissioner Okuda, the other general proposition, which is if you have stricter or more general, you go with the stricter. But because the legislature was so specific in this one amendment, it is very clear to me that the legislature is saying with regard to rural properties, the counties can do something other than what is in the 205. Specifically, they can make it more dense than what is in 205.
Okay, can I ask you a similar or same question that I asked Mr. Yee? If the county's interpretation and conduct is stricter than the plain language of the state statute, are we required to defer to the stricter application of the county's interpretation of their ordinance? And if your answer is no, we are not required to defer to the stricter application, what is your legal authority for that answer?
I don't think you're required to defer to the county. In fact, I think your jurisdiction ends and you don't even weigh in on whether the county's ordinance is appropriate or inappropriate, is consistent with the law or inconsistent with the law. Again, because of how the legislature amended 205-2C, I believe that it tells the commission that you don't have authority to speak to the county ordinances.
Okay. And my final question is this. I'm going to quote from an Intermediate Court of Appeals case. This goes to Commissioner Chang's question about exhaustion of administrative remedies. I thought it'd be good to at least have a statement of what the rule is, just so that we all are kind of, have some definition. The case is Leone, Leone versus County of Maui. It's an ICA case found at 128 Hawaii Reports 183. The Pacific Third citation is 284 Pacific Third 956. It's a 2012 case. And let me quote from the case, quote, although perhaps less explicitly, Hawaii case law is in accord. Under the exhaustion doctrine, quote, if an administrative remedy is provided by statute, a claimant must seek relief first from the administrative body before judicial relief is available. And there's a citation to a case, Williams, WILLIAMS versus Aona, AONA, 121 Hawaii reports, page 1 at page 9. And then there's a Pacific Third citation. And I continue on. In such cases, in the interest of judicial economy, quote, the doctrine of exhaustion temporarily divests a court of jurisdiction, close quote, close quote. And that last sentence bears a citation of, let me withdraw that point there. There's just a quote at that point in time. Does that sound like an accurate statement of what the doctrine of exhaustion of administrative remedies basically is?
I would agree with that, but I don't believe it's applicable to the issue that we are presenting here.
Okay, you read my mind. Why is that not applicable? In other words, why wouldn't this be in the interest of economy, judicial or otherwise, given all the things that have been talked about here, including what Commissioner Wong told us about what's pending down at the legislature, which may or may not pass, but it's still down there also. Why would it not be in the interest of overall economy and efficiency that we don't take this up right now?
I think there are two different questions being asked there. As far as the exhaustion of administrative remedies, that would be accurate if we were complaining about the building permit and it not being issued or being issued or being denied. We're not complaining about that because we don't know what the county is going to do about that. What we are doing is we are asking for an interpretation of the Chapter 205 before this body, Chapter 46 before the circuit court, to get an understanding of how this body and the court would look at interpreting those statutes. Now, whether that will be applied later on in the administrative proceeding with building permits, I don't know. But that's with the exhaustion of administrative remedies. What I think you're pointing out with Commissioner Wong is that the commission may be rendering, and I think I spoke with this Commissioner Chang, the commission may be rendering a declaratory order on its interpretation of a statute, which may no longer be in existence in 4 months. And should the commission defer to wait to see what happens, what the legislature does? I can't tell you that the commission, that it would not be wise to defer. In fact, if I were a commissioner, I think I would vote to defer to see what's going to happen because, as you point out, it does no one any good to issue declaratory rulings or orders interpreting a statute that no longer exists. It just doesn't help any of us. So I don't know if that answers your question, but I see it as two separate things.
Yeah. And Mr. Geiger, I appreciate what you've said. at the old courthouse, I always appreciated the legal discussions with you at that time. And here we are almost 40 years later, and I still appreciate the discussions. So thank you very much for your answers. Thank you, Mr. Chair. No further questions.
And if I could, as do I.
Thank you. Commissioner Cabral, followed by Commissioner Ohigashi.
Okay, yes, thank you, Chair. And in regards to dinosaurs, since I think I'm older than all of you, I'm not necessarily appreciating that. So, but regardless, okay, yes, Mr. GRIER, you made a reference a little bit ago that this is really the theory, not necessarily the specifics of your client's application for use of the land. So I just have a question to you because I'm not a lawyer and I'm not learned like my fellow commissioners Okuda and Chang and Ohigashi, but I do understand condominiums and subdivisions, as I have managed a few of them over my career. So what I'm hearing is that a person owns some land and they chose to go down through Hawaii Revised Statutes 514B or A at the time and develop it as a condominium, okay? So they develop it as a condominium using that level of law to do what they want to do. And those over here on the Big Island that have done that are usually averting subdivision law and requirements of the county, but I don't know your situation there. So, but anyway, so they do the condominium and then they come along a while later and they don't want to apply condominium laws, but now they jump over and they say, wow, the subdivision laws will allow us to have an accessory dwelling for each of our condominium units. And so now we want to not go through what we originally would have developed through as 514B, but we're going to jump over and use other land use law. Is that what you're saying, that you think is that as an appropriate use of condominium law or the zoning laws? Is that what we're looking at here?
The answer is no, that's not what we're looking at here. What we have is a specific request on a specific statute for the Land Use Commission. The development of this particular parcel was done as a horizontal condominium under 514B. It created 5 separate spatial units on which, in accordance with the laws for the property as zoned and as classified, the Mr. GRIER determined that he could have 4 main houses and up to 2 accessory dwellings. He chose to only have 1 accessory dwelling. So he applied for building permits, 4 main dwellings on 4 of the units and an accessory dwelling on 1 of the condominium units. So it's not an attempt to get multiple accessory dwellings on a condominium unit, but rather it was the ability to use the existing laws to develop a parcel to have the amount of housing that was allowed by the Maui County Zoning Code.
Okay, my question then is, my understanding is when condominiums are developed, and I don't develop them, I only manage them, they are not really a land division, they are a building division. So most of the ones I've dealt with have always had a structure on them when they're dividing out the land. And over here, it's been a permitted tool shed often, and then the house is built later to match the tool shed. So when your client did these to his 4 condominium units, did he already have the houses built? I mean, what was he dividing? He wasn't doing land, is that correct? He was really working with improvements on the land that he condominiumized or agreed to condominiumize when he got his permits for his condominium?
I think we're getting a little far afield of the question that's before the commission, but in answer to your question, the way the condominiums at least work here is that spatial units are created. And then after the spatial units are created, the condominium is created. The developer can go in and obtain building permits to construct structures within the spatial unit. And that's what happened in this case.
Okay, I'm not quite sure I'm really far off of it. I feel like we're going to use one set of laws to do what I want to do. And then now when I think it's beneficial, I'm going to I want to jump over to the other set of laws. But again, there's smarter people on this group than me. I'm very practical about it, but thank you for your opinion. Thank you.
Thank you, Commissioner Cabral. Commissioner Ohigashi.
I dye my hair white so I can charge more rather than doing it. But besides that fact, I was just concerned. The first issue is that you claim to be an interested party in bringing the declaratory ruling. And in your verification, you said, Mr. GRIER says that he's an individual who owns property within the state of Hawaii Rural District. Can you just expand on that so that at least we have some kind of thing in the record to make sure that?
Sure. Thank you very much. Mr. GRIER owned the property that was condominiumized. He then transferred the ownership to actually his wife, who then transferred the ownership to an entity. The entity is solely owned by Mr. GRIER. One of the condominium units is owned by the entity. Mr. GRIER also applied for each of the building permits.
But technically, he owns the entity that owns the development.
He owned the land. He then transferred it to his wife, and one of the units was transferred to an entity he owns.
And I'm just curious how this works, Mr. Geiger. I just was wondering. You indicated that he was allowed 2 accessory dwellings. Why is there a limitation? And technically, you should be able to get 4 accessory dwellings following the county's view.
Well, I'm not going to speak for the county on what their view is, but the way a condominium is treated, it is treated as a single lot. So therefore, he would be entitled to, because the lot is greater than 7,500 square feet under county ordinance, he'd be entitled to 2 accessory dwellings on that single lot. He did not seek to put up 2 accessory dwellings. He only sought to put up 1 accessory dwelling. But again, if we're getting there, I think we're getting beyond what the scope of what the commission can really rule on and opine about. I think you're limited to 205. You shouldn't be going down the ordinance trail.
I was just curious, reading the counties and the states memorandums, so that came into my mind.
I do have one comment on that. Oh, I'm sorry, go ahead.
That was fine. But the last question that I have is that if we limit it to 205, an interpretation under 205, wouldn't that necessarily legitimize or imply that we are ruling under 46? Say that, yeah, the county has to follow 46, or the county's interpretation or the rules must follow 46.
I don't think you would be going that far. I don't think there's an inference. I think, in fact, if I were the commissioner advising the commission, I'd tell them that we make no determination on chapter 46 because it's outside of our purview. I think that you're limited to saying only that the county can adopt an ordinance to allow Ohana zoning within the rural district, period.
And does the statute say that directly?
The statute says that except as provided in 46C4. the legislative history said that that amendment was adopted solely for the purpose of allowing Ohana zoning on lands classified as rural within the rural district.
So let me get this clear in my mind, because sometimes the dye affects my brain. The question I really have is, what exactly are you looking for us to determine or to actually rule in this case? In other words, give me what you want. Give me, just say, hey, the county, is it that the county can pass an ordinance regarding Ohana zoning? Is that what you want? No.
I wouldn't put it quite that way. I think the chair, when he initially called the case, had stated it succinctly and correctly, that the issue is whether or not Chapter 205 limits the density of structures on the rural district to 1 per 1/2 acre. And your declaratory ruling is no, the limitation is subject to reasonable ordinances concerning zoning that have been adopted by the county.
Or we could say that, yes, it limits it. However, we make no ruling on all 46 offenses.
That's correct. That would be the same. Actually, I think it's not that it does not limit it, but you make no ruling.
No further questions.
Thank you. Commissioners. Commissioner Cabral.
Yes, sorry, you keep saying things that make me have more questions. So you said that there's 3, but there'll be a 4th condominium unit on the property. So are you saying that all of the the lawns between the different structures are common area owned jointly by everybody? And it's just the building structures that are owned separately, or is the land itself, because each of those in condominium law can be sold to a different person, correct?
Okay, you have a couple of questions there. Let me try to go at it this way. When you create a condominium, you have basically two property parts. You have the common elements and you have the units or the apartments. The way horizontal condominiums are created is that you have the common elements, which is usually a driveway or access area, and then separate spatial units. And those spatial units are generally identified as limited common elements, usable by the persons who buy those separate units. Does that answer your question?
No, so you are saying that the limited common element around my house, if I buy that, is going to include however many square feet, and I mow it myself and I can fence it myself per your documents. So, okay, I got the picture.
That is correct.
Okay, so the next question is, if I add on accessory dwellings, then is that accessory dwelling going to be subject to being able to be sold to a separate entity, each accessory dwelling on my limited common element? If I add accessory dwelling to my limited common element, can I sell that to somebody different as if it were a condominium unit?
The answer is no, unless the condominium unit, the owners of the condominium agreed to amend the declaration to increase the number of condominium units. It simply would, first of all, I don't think you'd get a building permit. And secondly, I don't believe you could further subdivide, or excuse me, further condominiumize the property.
Okay, that's what I'm thinking too. Okay, thank you very much. It's an interesting concept you have. Thank you.
Commissioners, further questions?
Chair.
Commissioner Wong.
Thank you, Chair. Mr. Geiger, I got a question. You know, from what I know it's a little tangential to this deck order in front of us, or deck ruling. But why did, I mean, your property that's being worked on, how come you didn't go for subdivision instead?
I can't answer that question because I was not involved in that particular aspect. I can only tell you that we have a 2.02 or 05 acre parcel that was condominiumized into 5 units.
Okay, no, just because whenever I hear condominium, especially in Honolulu, I think of like high rises that's high density, not low density. And I think, when I think of ag or rural, it's low density, almost nothing there, just to say cows or horses or sheep or whatever, or even yaks, So I'm just trying to figure out, what is this, what is your difference in that condominium issue?
Well, first of all, remember that this is rural, designated rural zoned.
Okay.
It is not ag land. And so that allows for residential use and an increased density.
Okay, so but isn't 205 dealing with more low density issues?
Well, and I would submit that this is a pretty low density issue.
In a 2 acre parcel.
In a 2 acre parcel.
Okay, that's it. I just needed that clearance in my head. Thank you, Mr. Geiger. Thank you, Chair.
Thank you. Are there further questions from the commissioners at this time? I have a brief question for Mr. Geiger if you wish to share or opine. If I understood first you should correct me if I've misunderstood you in your written or oral presentations, but if I understood you correctly, you said we can comment on 205, we can't really comment on any other part of the Hawaii revised statutes. We can't rule on it, on how it's interpreted. But really, it seems like the crux of the case has to do with how this part of the Hawaii revised statutes interacts with another part of the Hawaii revised statutes. Is there some kind of principle that you suggest where we draw that line to answer these questions if we chose to rule?
I don't know that it is a principle, but in this particular case, because of the legislative history on the amendment that draws in 46 4C, the legislature made clear that 205.2 and 205.5 should not prohibit reasonable Ohana zoning ordinances. And so because the legislature made clear that it was outside of 205.2 and 205.5, in this particular case, I believe you should not weigh in on the interpretation of 46. I think that uniquely goes as part of county zoning ordinance and whether or not the county's ordinance complied with that, which is the issue that, well, one of the issues we have before the circuit court.
But doesn't the interpretation of, or the understanding of that legislative history depend on some interpretation of what reasonable is?
Reasonable in terms of a zoning ordinance. This is not what's reasonable in terms of the meaning of 205.2 or 205.5.
Really? You don't think it had anything to do in the same sentence with what's reasonable? I mean, because partly I try to approach some of these issues from like just a common sense perspective. We have an urban district, we have a rural district, we have an agricultural district and conservation district. Rural presumably means rural. I live in the urban district on a 10,000 square foot lot, which is basically a quarter acre. I don't live in a rurally zoned state land use district. So I'm trying to, why wouldn't you look at reasonableness in terms of 205? I don't understand how you interpret that differently.
Because again, the legislature specifically carved it out in the legislative history. They said We want to make sure that Ohana zoning is allowed in the rural district. Therefore, we have this exception for Ohana zoning in the rural district. And after that, I think that the commission gets on thin ice if it starts to interpret whether or not the county's ordinance is reasonable or whether or not the county's interpretation is reasonable.
Even though the legislative history discusses reasonableness.
The legislative history, I believe, on the reasonableness is more with 46.4C rather than 205.
I have nothing further right now. Thank you.
Thank you.
Let's see, commissioners, anything else for Mr. Geiger right now? If not, I said I would give the opportunity for the county to say something more, and Mr. Yee wanted to give his main presentation later. Anything more from Mr. Geiger at this time? I will give Mr. Geiger a chance to rebut anything at the end.
Just reserve the right to comment on what the other.
Yes, I just said that you may rebut anything. You'll get the last word. Well, the commissioners get the last word. You'll get the second to last word.
Or third, thank you.
Commissioners, anything further from Mr. Geiger at this time? If not, Ms. Tarnstrom.
Thank you, Chair. I do have several comments to make in response to the question and answer of Mr. Geiger. First, Mr. Geiger identified this petition as a 205 question, wherein you didn't have to consider 46.4. But that actually conflicts with exactly what was written in his petition. In his petition, it says the issue presented is whether HRS chapters 205 and 46 restrict a county's ability to provide for greater density. I think it's incumbent upon the commission that they must be able to interpret how 46.4C is enfolded into the 205 requirements. 205 explicitly adopts the exception of 46.4C. You do not have to analyze the actual text of it if you don't want to. It's very clear, but it does limit the state rural density entirely based on that section. So it is incumbent upon the commission to be able to review it on this question. Using more common sense perspective, I guess, there's no better body to answer how many dwelling units are allowed on a plot of state rural land. This is the body that can clarify this question. And again, that goes to the nature of this case. It's not an appeal. We don't have a final decision. We have the petitioner and the county essentially making a joint petition to ask this body, what does the law say? And in this circumstance, are we correct or are they correct? It's not a joint petition, but we bring this before you to hopefully get clarification on what the law instructs us to. We had considered bringing a joint petition. We had also considered just bringing one on our own behalf, because obviously the department has to interpret this on a daily basis. And if it were somehow wrong, it would have to change how it's interpreting this for everyone it applies to. As to the more jurisdictional question also, there aren't any truly disputed facts in this case. There's nothing that would occur that would change how, in terms of the underlying facts of Mr. GRIER's circumstances, there's nothing that's going to change the county of Maui, the department's planning position on this. The only thing that would change it is a decision from this commission. And again, this is a declaratory request. It's not subject to appeal considerations, which I think were discussed by Commissioner Okuda. Again, yeah, it's just about this commission's role to help clarify what is not, which is a clear question to the department, but clearly it is subject to interpretation by those who are existing under it. The proposed bill identified by Commissioner Wong is extremely relevant to all of us, I think. However, I think that the underlying question isn't mooted, especially from the department's perspective, because while we're dealing with the 1 house per half acre in this case, in the next case, we might be dealing with another applicant who has a half acre and wants 4 houses when they, only have 2. So it actually would really assist, I think, everyone to have some clarification on the interplay of these 2 statutes. It isn't mooted if that bill, which is obviously speculative at this point, but even if it did pass, we would have greater clarity should it go forward. Again, the circuit court case, that was brought, it wasn't brought as technically a declaratory action, it was brought as a special petition, which the county had procedural issues with anyway, and in discussions with the petitioner. I think we came over petitioner's initial reluctance to come to a point where we would seek this body's advice on this very question. I don't think exhaustion of administrative remedies is, it's definitely interesting to consider in this case, but it's more of a circuit court consideration and whether or not the circuit court has jurisdiction over a challenge to a director's action. In this case, we kind of have, like I've demonstrated, a request for clarification of this law. Maybe finally, but as to the legislative history, or really to go back to the interplay of 205 and 46-4C. Again, as I've said, the statute very clearly limits density specifically, except for the exception in 46-4C, thereby bringing that statute underneath the Land Use Commission's purview for the limited purpose to consider how it interplays with the land use statutes. And you cannot consider this question about how much density is allowed in this circumstance and in future circumstances without considering this 46-4C limitation. And like I said, the petitioner spent much of his brief talking about 46-4C. I don't know if he ever actually quotes it, except in the, talks a lot about the legislative history of it, but doesn't actually just come right out and say it. This statute says, each county may adopt reasonable standards to allow for the construction of 2 single-family dwelling units on any lot where a residential dwelling unit is permitted. It doesn't say there's an unlimited amount, a reasonable amount of dwelling units. It says the county can create reasonable restrictions and rules to create 2 dwelling units where 1 is allowed. It's very specific. So you don't have to interpret the ins and outs of that statute necessarily to apply it to 205. It's very clearly a limitation that's adopted by 205. And as to this, much discussion made of the 1989 bill, that is Act 5. It's attached as Appendix C to the department's brief. This reasonableness question is about the reasonable standards to allow 2 houses where 1 exists. That's the only portion where reasonable comes in. There's no question that there's only 2 that the county can create in place of 1. So to say that you can interpret this petition and this question about 205 without reading the text of 46-4C and simply taking the petitioner's idea of what it means and not actually reading it and applying it to the statute is incomplete. This commission clearly has jurisdiction over that question. And that's essentially what we're here to discuss. I just want to check my notes to see if there's anything additional I wanted to address.
Go ahead.
Thank you. Yeah, I think that's it for now. I can take questions.
Okay. I'll allow the commissioners asking questions. I do want to know that I want to take a break in 5 minutes at 2:30. And then can I just do a, sorry, Commissioner Ohigashi, you're muted, so I could not hear you.
I just was wondering if we can take a break now. Rather than 5 minutes.
Okay, well, let me check. Commissioners, how late can we go today? Who has restriction coming up? Commissioner Giovanni, are you trying to? Commissioner Cabral?
I'd like to leave at 4 or 4:30 if possible.
Okay.
I'm good today.
Okay. Okay. It's 2:26. I'd like to take slightly longer. I'd like to take a 20-minute break rather than a 10-minute break. It's been a long sort of run at things. So we will reconvene at 2:46 and we will have questions, final questions for the county. Thank you.
You are so generous today, Mr. Chair.
Okay, we're back on the record. And questions for Maui County, starting with Commissioner Chang.
Thank you, Mr. Chair. Is it Miss Tarnstrom? I guess I have one factual question. Based upon the representation by Mr. Geiger, they have submitted building permits for four building permits and one accessory use. And the county has denied, after issuing the building permit, then subsequently denied the permit for, as I understand it, the accessory use or the fourth permit. I'm just trying to understand the facts here. This is because you had told me you had denied the fourth and sixth building permit, and he said it was the fourth. And reading through the documents, it's not really clear. So factually, I'm trying to understand what exactly has been approved and what's been denied.
I understand the confusion on that. I was definitely wrong. I would rely on Mr. Geiger's representation. From what I understand, there's been there were 3 building permits issued. Jim, you can nod. Okay, and then 2 that were applied for, but they have not been decided upon yet. And at one point, the fifth one, whichever one that fifth one ends up being, is going to be one too many, and they will only act upon 4 dwelling units on the land.
So that's my understanding, is that the county will permit the petitioner 4 units on the property, on the 2.02 acres. Is that correct?
That is correct.
And that what's in dispute is whether the county, what's in dispute is that fifth building permit, whether it's for the accessory use or for a separate building. Is that correct?
That is correct. Just to explain a little further, the 5th building permit, I think there is intended to be even a 6th, but that 5th one falls outside the allowable number of dwelling units for how the county interprets the interplay of the state statutes.
So based upon the county's interpretation, they are only permitted 4 buildings. And you define a building, whether it's an accessory unit or the building, it is no more than 4 because it's rural district on half an acre each. And so there would be a maximum of 4. Is that correct?
That is correct, yes.
And Mr. Geiger's client has applied for at least 3, been granted the 3, and actually may have even built units on the 3. The outstanding is the one application that includes a building and an accessory use. Okay, I will ask Mr. Geiger, he's shaking his head, so that must not be correct. So I will ask him, I am just confused. So let me ask you the question for the county. And I'm not suggesting I'm inclined to go one way or the other, but if LUC acts on this declaratory ruling action and decides in favor of Mr. Geiger's interpretation and not the county's, what impact does that have on the county beyond this one petition?
I believe,
if any? I'm sorry, go ahead.
Given if the commission were to adopt Mr. Geiger's interpretation of the interplay of these statutes and what it means to the county, then the director can correct me, but I believe that would change how we, if we accepted the decision and didn't appeal it, et cetera, et cetera. I believe that would change any number of applicants who came in, and I believe it would change the number of buildings that we now would believe and understand to be allowed in a state rural district.
Okay, 2 questions. One, you said if we agreed with Mr. Geiger's interpretation and we didn't appeal it, so are you telling me that you can appeal the declaratory action by the LUC?
That's my understanding. I think Mr. Geiger and I discussed that as we were discussing procedural mechanisms we can use. Yeah, but we don't, at this time, it's uncertain whether we would even appeal it. We just kind of want an answer.
Okay. And what impact, if any, would it have? Well, let me ask you this. I'm assuming, have you in the past made an interpretation of the 2 statutes in a way that this Mr. Geiger's interpretation would be contrary to actions that you've previously taken?
Oh, any previous case that's closed and decided would be undisturbed. It would be a matter of what applicants could request going forward as we review building permit applications and so forth.
So based upon your understanding of what Mr. Geiger is asking for, what impact would that have on your interpretation?
Well, you mean what's the conflict between our interpretations?
Yes, I want to know as a practical matter, what's the difference?
Well, the way the county's viewing this is that the state land use statutes prohibit the county from allowing additional accessory dwellings. So the way we interpret it, state land use statutes require there only be 4 dwellings on this 2-acre plot of land. Mr. Geiger's interpretation or the petitioner's interpretation is that state land use allows 4 and county zoning allows 4 buildings on this. But given the application of 46.4C, he believes that exception, we believe it's a very limited exception that doesn't apply here, but he believes that exception incorporates the county law, which allows 2 additional dwellings. And in that case, he would be permitted to have 6 dwellings on his 2 acres. So we believe that you don't even get to the county accessory dwellings because the state puts a cap on it, basically. And Mr. Geiger believes the 46.4C basically pierces that and allows you to kind of get to, allows the county to decide how many accessory dwellings are allowed on a rural lot. And
okay, so what is your, I'm sorry, so
No, I'm just hoping I explained it in a way that made sense. That's all.
So what is your response to Mr. Geiger's interpretation that 46-4C, that is an exception to 205 that would permit, in the case of Ohana zoning, would permit the county to exceed the limitation of 2 dwellings per acre?
That's a great question. Thank you. If it's been at all unclear. So 46-4C definitely applies in under 205 and in rural zoning. Our belief is that it's a very limited exception and that it only applies when there's one house that's allowed on the lot. And in that case, under 46-4C, where there's only one house, the county can allow a second house. And under Mr. Geiger's interpretation, he's saying 46-4C applies, generally speaking, to allow the county to allow any number of, a reasonable number of additional dwellings on the lot, which we just believe that's not at all what it says.
So let me try to understand the county's position. 205 refers to acreage. You have an acre, you can have 2 dwellings. On each dwelling, now for the county, when 205 applies to 1 acre, 2 dwellings, do you define the dwelling as a lot?
No, that's a good question. So 205 allows 1 house per half acre. And we believe that the exception under 46-4C only applies in that very limited instance. If you have 1 acre of land, you're allowed to already have 2 houses on that land. And therefore 46-4C doesn't apply because you're already allowed 2 houses. And then if you have 1.5 acres, you're allowed 3 houses. And 46-4.3 only pertains to when 1 house is on the land already, and so forth. Does that answer your question?
Oh, I'm not clear on the county. So what's your limited exception? How do you define that?
Okay, so it's I don't blame it for not being entirely clear because it's complicated, but the limited exception. So 46-4C says that counties can create reasonable standards to allow 2 houses anywhere a dwelling is allowed on a lot. And that applies everywhere, residential, urban, whatever, everywhere. As it applies to rural districts allow multiple houses based on how large your land is. So in our opinion, since the exception only allows us to make 2 houses where 1 was before, it only applies in a rural district on a small half acre to 1 acre, less than 1 acre plot of land where you're only allowed 1 house. So that's the narrow exception it applies to. Anytime you're allowed more than 1 dwelling on a lot, 46-4C doesn't come into play because it only allows 2 dwellings where 1 was.
So as I understand, I'm trying to understand the county's position. You're saying if there's 1 acre, they're allowed 2 dwellings, no dispute. Do you agree with that?
Absolutely.
If it's less than 1 acre, so let's say it's, it's half an acre. So they're allowed under 205, they're allowed one dwelling. Mm-hmm. That is, and so explain to me now, so how does the county apply? What is a limited exception when it's less than 1 acre? What's your interpretation?
Is that under the circumstances where it's half an acre and you're allowed 1 dwelling, then the exception comes in and allows the county to give you another house. but if you already, to allow you, not to give you, but to build another dwelling. And then if you have 1 acre, you already have 2 dwellings. We're only allowed to turn 1 into 2. We're not allowed to turn 3 into 4 or 5 into 6 or 6 into 10. We can only allow, the Ohana zoning allows us to make 1 into 2. So it's only relevant in state rural zoning where there's only 1 house allowed, and that's only where you have a small lot that is less than 1 acre. Otherwise, it just doesn't apply.
Okay, so your limited exception, 205 relates to acreage, 2 homes per acre. Your limited exception applies to where there's less than an acre and they're only permitted 1 dwelling. Then under that circumstance, the county says that's when that exception is triggered, where you can allow more than 1 house on that half an acre. Is that what you're saying?
Absolutely. That is absolutely what we're saying.
And so are you telling me that within that half an acre, the county can permit how many houses? And that's when the reasonableness comes in. So does that mean that you can allow, what does the county consider reasonable on a half an acre?
There's no, our position is that there's no word reasonableness.
Okay.
That's relevant. We're only allowed 2 houses where 1 was. Mr. Geiger's position is that the county can kind of decide what's reasonable and allow what it wants.
Okay.
In any circumstance under 46(4)(c). And we're saying, we're arguing our limitation. We're saying we're just limited by the state law. And if we're not limited, you know, we can do whatever we want. But if we are limited, which is what we believe we are, there is no question of reasonableness. There's just that strict to where 1 was.
So when it says each county may adopt reasonable standards to allow construction of 2 single-family dwelling, the county of Maui's position is reasonableness is not the number of dwellings. There's other, that applies to other standards.
Right.
The only thing that you're allowed to do is you can allow 2 dwellings on less than an acre, on half an acre. You can allow, let's say you had 10,000 square feet. Could you allow 2 dwellings?
I'm really sorry. I don't know. Is that how big an acre is?
Acres,
roughly a quarter acre.
That would be
That's a quarter
one quarter of an acre.
A quarter of an acre, since I believe there'd be no homes allowed on that lot because it's too small. Is it? No, you can get 2. Oh, okay, yeah, you can get 2. Sorry, under the same rule.
Okay, so on a half an acre, the county would permit 2 dwellings.
Yes.
On a quarter of an acre, the county would allow 2 dwellings.
Correct.
So you're saying no matter, so long as it is less than an acre, the county will allow a maximum of 2 dwellings.
Yes.
And you believe Mr. Geiger's position is that 46 allows the county to allow more than 2 dwellings on less than a half an acre.
I believe that is the logical conclusion of what he's arguing, even though he's not specifically saying that. He's saying it gives the county's power to allow a reasonable number of accessory dwellings, whereas we don't think it says a reasonable number of accessory dwellings. We think we're only allowed to add 2 where there was 1. And that's based on the may adopt reasonable standards to allow construction of 2 single-family dwellings.
Okay, so now I think I understand the county's position. Reasonableness does not the number of dwellings, but it may be related to other building standards.
Exactly.
The maximum number of dwellings that the county believes they can permit under 46, if it's less than an acre, is 2 dwellings.
Yes.
And in the county's position is So they could have, so in 1 acre, you cannot have more than 2 dwellings. That's the
Right.
max number. In a rural.
For a lot size that is 1 acre, yes. But that's based because the exception doesn't apply. And that's just based on there being allowed a dwelling per half acre.
Okay, and that's how the county has been interpreting this limited exception, only applying to lots less than an acre, where there's only 1 house permitted. You believe that the county hasn't been interpreting it where you can permit up to 2 dwellings.
Yes,
Okay,
exactly.
okay. All right,
Thank
very
you.
good. I think I
Taking the
understand.
time to get that, yeah.
Thank you.
Thank
Okay,
you,
yeah, I
Commissioner.
can, if you would like to look, we have attached Exhibit D, Appendix D.
Which is a
And, yeah, that's a graphic that was created by the department to kind of help identify how we've interpreted this.
I will take a, thank you. Okay, thank you.
Thank you, Commissioner Chang. Commissioner Ohigashi.
Thoroughly confused. Got, I'm going to try and keep my question simple. Are you saying then that your request is that we establish that there be a limit of 1 house per 500? Let me take it. 1 house per half acre on any lot?
That is what 2052 and 2055 states. But
Would
we
it-
adopt, yeah, sorry.
So that is your position. Second question is that, are we required, or are we, isn't it correct that 46, chapter 46, and its implication and how it affects 205 is not within our purview?
I would disagree with that. I do believe that.
Could you
that-
tell me what, could you tell me the basis for your
Sure.
disagreement? And
Because-
try and lay out if you have any authority or anything like that.
Sure. I didn't anticipate this and it wasn't brief, so I don't actually have legal authority for this apart from what is understood in interpretation of the land use statutes, and that's 205. And in 205, they adopt a limitation or an exception identified in 46.4. And so as it pertains to 205, that statute can be interpreted as it's interplaying with 205. That's our position. We can't just bring an action before you and say, interpret 46.4 right now, and tell us what it means. But we can bring an action and say, 46.4 is adopted into 205. So can you tell us how these interplay? Because this is the land use statute and you guys are the guys who can give us answers to that. So that's how we see it.
And just for the record, is that you didn't file any documents or you didn't file any your own petition in this matter, is that right?
No, that is totally correct. Yes, we did not file our own petition. No.
As the chair indicated to you, is that there's only one party in this case, and that would be Mr. Geiger's client.
Absolutely.
I understand that. And therefore, I'm not sure if you have even appeal rights in this matter. Is that right?
I think we may, because we are an interested party that submitted and participated in the.
Well, I'll leave it up. I'll leave it up to the Supreme Court to decide that later.
Okay, sure.
But yeah, so what I'm trying to get at is that if we accept your determination or your argument, wouldn't it be indirectly approving the county ordinances that you're trying to protect here or trying to enforce here?
No, actually, we are not. It's the petitioner, Mr. Geiger, who is trying to enforce the county ordinances and bring them into this case. All the county is trying to do is properly interpret the limitations placed on the county by the state land use statutes. And so we believe that we've been limited in what we can apply in this circumstance. We have we don't think the county codes are at all relevant in this case.
Can you direct my attention to, in your filings, I was just trying to look at where in the county code that you cite expresses this limited exception that you have articulated concerning this matter?
Sure, it's not in the county. It's not in the county code. It's in 205. 205 says that there can be one dwelling unit per half acre, except as provided in 46.4. And so we're just interpreting 205.2 and 205.5 and interpreted this exception.
So there is a county code that says essentially that you can have, if you're 7,500 square feet, you can have, or more, you can have 2 accessory dwellings if you're, right?
Yep, yeah. But
did that indicate, or did that have a limitation on its application to 1 acre, 2 acre, 3 acre, 4 acre lots? Is there some kind of limitation contained in your own county code that?
Yeah. Sure, in county zoning, if we're looking at the county zoning and not the state level zoning. So if you're looking at county zoning, you can look at my brief, where is it? And it is cited on page 3. So independent of any state level zoning, if you're just looking at the county zoning, under county law, not limited by the state if it weren't, it says you can have 1 single family dwelling per half acre, and that's under 19.29030. And the county doesn't limit, the county would allow 2 additional accessory dwellings purely under county code. And that is identified in section 19.35.050. So if there were no state land use limitations, the county law would allow 6 dwellings. But the county law also adopts and recognizes the limitations of 205 if they apply. And we believe they apply in this instance. So state zoning says, we believe state zoning limits it to 4. And since state zoning applies, we have to limit it to 4 under county code. But if none of that applied, it would be 6 dwellings.
So what you're saying is that there is nothing in the county code that refers to any state limitation this matter, and that you are relying upon purely our determination or the state law that's saying, which 205 says 1 unit per 500.
Basically, there's only one point that I would argue that there's, under the rural districts of county zoning rural districts, it states accessory dwellings are allowed pursuant to the county code accessory dwellings, which is 2, but also pursuant to 205. So under the county code, in adopting limitations in 205, which apply in this case, yes, the county code identifies that 205 can limit the number of accessory dwellings.
So I just wanted to understand your position. The last question I had is that assuming that the statutory amendments is passed, that Commissioner Wong had indicated, on this particular property, would it be correct that 8 dwelling units would be applicable?
If I understand that proposed statute, I think that, yeah, it would be 8 because you'd be allowed as many houses per quarter acre, and that, 2 times 4, I think, is 8. So yeah, it would be 8 units. So in this case might be mooted depending on what the petitioner wants on their land, but it wouldn't moot the issue for the department because we'd be facing it down the road.
However, again, the department didn't file a petition in this matter.
True, yes.
So we are under no obligation to give the department to issue a declaratory ruling concerning the department.
Absolutely.
No further questions.
Commissioners, anything more for the county? If I may, at the hope of making a complex and confusing issue further confusing and complex. I was starting to think about how the differing interpretations of the relationship of 205 to 46 might impact the LUC's public trust responsibilities. And particularly when it comes to the consideration in Hawaii Supreme Court rulings of the existence of traditional and customary rights on lands that are less than fully developed. At what point, when you start to add units onto a rural lot, might the land start to go from being less than fully developed to fully developed? Ms. Tarnstrom.
I think putting dwelling units on a plot of land, depending on how you're defining development. Under, say, the SMA, it wouldn't be a development, but if you're using that term very broadly, anytime that you're building anything on land, you are developing it. And I think it would be essentially incumbent upon, from what I understand of the Hawaii Supreme Court's rulings, incumbent upon the petitioner to establish that they are not infringing upon traditional and customary rights if they are in fact disturbing, if it does qualify as a development under any statute or code.
Well, I guess what I'm trying to get at is by essentially having an interpretation of county, your ordinance in relationship to 205, you are limiting density, correct?
Yeah, I would just clarify, we don't think our county ordinances are at all relevant in this. We are just interpreting state statutes. And we believe that the state statutes limit density and that we can't go beyond what the state statutes tell us we can do.
I'm fine with that restatement of your position.
Okay.
But that position would actually act to limit density.
Yes, I mean,
and
yeah,
hence perhaps serve as a mechanism for possibly protecting the exercise of traditional customary rights in the rural district that might exist.
I think that that's fair. I think any limitation on development has a more potential to protect traditional and customary practices.
Okay, thank you. Anything else? Commissioner Cabral?
Just to complicate things more, I'm going to go back to 514B. As Mr. Geiger said, all of that land is now being seen as limited common element under a condominium statute. And so that would have to be, we've only got, in a sense, one owner under various names or entities, then they can vote to make that change. But I think that that's a whole nother law, and they have to go back and change the public offering statement, development. You know, that it only muddies the water that much more if they chose that method. Or even maybe they can go back.
Commissioner Cabral, you're cutting in and out a little bit.
Oh, I'm sorry. Okay, well, I'll talk into my computer where that's at. Anyway, I'm just concerned that this is such a muddy mess because that they really, as he's indicated, are under 514B condominium law. And that land that we're all discussing is really, he said, limited common element under the description of how they've set up that property. So they can vote to maybe change that, but I think that that's a whole nother can of worms for this property, legally speaking. Okay, and I'm not the lawyer, I'm the condo person. Okay, that's all. Just, it's a mess. Thank you.
Thank you, Commissioner Cabral. Anything further?
I would just state that this is all, oh, sorry, from me or from Commissioner?
From the
Cabral?
commissioners.
Okay, sorry.
But if you had something more, I would allow it.
I was just gonna say, it's really hard to break this down, put it on paper and understand it. But if you step back from it, it's really just about like what limits is a state law putting on this plot of land? And does this exception in 46.4C, does it mean this county can give whatever amount of accessory dwellings, or does it limit it in this circumstance? And so
thank you.
I don't even think that simplifies it, but it's all very complicated.
Thank you. Let's move on to Mr. Yee.
Thank you. So let's first recognize that I think all of the parties agree that the more restrictive of the requirements apply, whether state or county. To start with the first question, I think Commissioner Okuda had asked. If the state requirements are more restrictive, they must apply, regardless of what the county says. So if the county allows more units, if the state statute restricts the number, then that is what has to apply. This is also reflected, by the way, not only in the Sunset Beach, but also in the Hawaii Administrative Rules of the Land Use Commission 1515-23. So let's start with that. Then I look to what is the question before you today. And we've discussed a number of things, but I think we start with the question that the petitioner presented on page 5 of his brief, which says, the petition presents a single issue for determination, whether HRS sections 205-5C, 205-2C, and 46-4C restrict a county's ability to provide for greater density in the rural district than one dwelling per 1/2 acre. That's the question before you. It's not necessarily whether his particular application should be granted. It asks the more general legal question. And although I understand that there's been some confusion about about how to analyze this issue, from the Office of Planning's view, it's relatively simple. Chapter 205 says that the density in the rural district is one dwelling per 1/2 acre unless otherwise allowed by section 46-4C. That's the density. It's one dwelling per 1/2 acre, and there's an exception. So then you look at the exception. The exception says the county may have reasonable ordinances that may allow an accessory dwelling on a lot where there is a dwelling unit. That's the exception. And so the question arises, if you have a lot with 2 dwelling units, are you allowed to have an accessory dwelling? And the answer is no, because you don't have a dwelling on the lot as specified in 46-4C. You have two dwellings. You already have multiple dwellings, and therefore 46-4C does not apply. Part of the confusion arises, I think, because Chapter 205 sets density limits. These are density requirements. 46-4C is not per se a density requirement. It has an impact, but it is not specifically a density requirement. So let me give you an example to hopefully show the differences. Let's suppose you have a 1 acre lot. On that lot, you have one house in the rural district. You're fine. If you want a second house, you may ask for an accessory dwelling unit. There's only one house on it. You qualify under 46-4C, you may be allowed an additional accessory dwelling unit and satisfy the requirements for accessory dwelling units. Or you could CPR it. It's in the rural district, 1 acre. You could go through the process for CPR and allowed to have also be allowed to have 2 dwelling units. Or you could do a full subdivision request and subdivide the 1 acre into 2 half acres. And then you can then have 1 dwelling unit on each of those lots that are created because they meet the requirements of 205, Chapter 205. You reach the exact same result in 3 different ways, although they each have to go through a different process. And that's up to the individual landowner in their individual circumstance to decide which way they want to do it. We note that now there was sort of a question of what's the difference between a CPR and a subdivision. I think Commissioner Cabral addressed this very well. And she asked the question, and I don't have the exact wording, but so I'm going to paraphrase. But she asked, I believe the petitioner, are you asking whether you can get multiple units through a CPR to avoid possibly the subdivision requirements, and then ask to get the benefits of a subdivision by asking for an accessory dwelling? And the petitioner said no. But from the Office of Planning's view, the answer is absolutely yes. That is exactly what is being proposed. And that's important because a CPR is not a subdivision. A CPR is simply a means or method of ownership of the property. It is not a land use approval. A subdivision is part of the land use process. So if you go through a subdivision, quite frankly, it's harder. You have to go through, you have to answer more questions, you have to analyze more things, you have to provide more information. And that's why it's important in this case to make that distinction between a piece of land that has been CPR'd to allow multiple units, in which you are not allowed then to have an accessory dwelling pursuant to 46-4C, because you have not gone through the land use process of a subdivision with all of the requirements in analyzing the impacts of a subdivision. And so it makes a substantive difference in making sure the counties retain that control over their land use process when someone comes in and asks for an exception to the density requirements under 46-4C. So if you have a 1 acre piece of property and you CPR'd into 2 dwelling units for that 1 acre, that's fine, but you cannot then ask for, or not entitled to then get the accessory dwelling through the accessory dwelling process. You had to go through the much lengthier, or at least lengthier and more robust analysis of a subdivision. And that gives then the county more control in analyzing how the land is being used, and then being aware that that subdivided piece of property would then be entitled to an accessory dwelling unit. And that could then be part of the county process. So that this interpretation that the Office of Planning is proposing to you is then consistent with the larger land use processes that exist, subdivisions, CPRs, et cetera. Commissioner Wong, and by the way, Commissioner Wong asked, why not go through the subdivision? That's the reason, because it's more difficult. We join in, I think, the comments and answers by Maui County's council on this, particularly also the term reasonableness. The term reasonableness does not refer to the number of units. It doesn't matter whether whether the county ordinance is reasonable or not. They cannot allow more than one accessory dwelling on a lot where there is a dwelling unit. That's all that they're allowed to do under 46-4C. Whether the ordinance is reasonable or not, there's still a restriction on what they're allowed to do. Now, they could put in other reasonable requirements that you're only allowed to do it under certain circumstances, or you have to make a certain showing of proof of something or the other. Maybe you have to do a public trust analysis. Whatever the other standards that apply, the county can certainly impose additional reasonable restrictions and standards to apply before it allows the accessory dwelling unit. This is reflected, I think, in the legislative history in which it allows it doesn't require the accessory dwelling, it allows the county to do an accessory dwelling and gives the county that authority to establish reasonable standards. But it never changes the county's authority to allow greater density, a greater number of units. It's still only one additional unit on a lot where there is a dwelling unit. So I think substantively, that's, I think, the question and the answer from the Office of Planning. You have asked a variety of questions regarding whether the Land Use Commission should even decide this matter. And let me try to briefly discuss some of those issues. You raised the issue of legislation. There is legislation before that's considering whether or not to change the density in 205 from a half acre to a quarter acre. If that happens, it is possible that Mr. GRIER will be satisfied because he doesn't want to create more, assuming he doesn't want to create more than 16 units on his, or 8 units, I guess, on his property. I guess it would, more than that, all right. He could clearly be allowed to put in the 6 that he's asked for if that law passed, but it doesn't answer the question, the general question presented in this declaratory petition, which the county is asking and as phrased by Mr. GRIER in his petition. So it might deal with a particular issue, but it doesn't deal with the question presented to you. And it, well, okay, let's leave it there. Then there's the issue of 1515 dash, I think it's 90, oh, sorry, 100, which allows the commission to refuse a petition, to deny a petition, basically won't consider the question for a variety of reasons. One of which is whether it's speculative and does not involve an existing situation or one which may reasonably be expected to occur. So that was a discussion that I had with Commissioner Chang as to, how clear do the facts have to be? Is it a purely legal question? If you think it's going to be factual and therefore we're just speculating on what the answer might be because it's going to change in the facts, you certainly don't have to answer the question. I think in this case, the question is though purely legal. I think the question is, what is the authority of the county? You don't have to decide whether or not their ordinances are reasonable. It's just, can they pass a reasonable ordinance to allow more than one dwelling unit? To allow an additional accessory dwelling on a lot which already has multiple dwellings. And I think that's a purely legal question, which, as the county has said, comes up to them every so often. So it is a matter that does arise. There is the issue of whether, and I did misspeak a bit, I think, the precise language of your rules is you may deny the petition where the issuance of the declaratory order may adversely affect the interest of the state, the commission, or any of the officer or employees in any litigation which is pending or may be reasonably be expected to arise. So there is a slight difference in that the county and actually private individuals are not actually included within that rule. But I accept the idea that of expeditious and efficient undertakings and a desire not to have repetitive proceedings. So I think I would say that the commission has the authority to defer or refuse to consider an issue if it's already pending before someone else, and you've chosen not to answer the question. I don't think, however, that exhaustion of administrative remedies, though, is the right term to use. And I think a simple way to think of this is the court in the Second Circuit could look at this and say, well, you haven't finished your declaratory proceeding before the Land Use Commission yet. Go and exhaust your administrative remedies. Different than the Land Use Commission looks at the court proceeding and says, well, you haven't exhausted your judicial remedies. Go and exhaust those before you come back and ask us anything. So I don't think exhaustion of administrative remedies is the right term to use. Although I understand the idea of simply trying to make sure there's simply one forum in which decisions are reached. And so it's a bit of a chicken or egg question. I do note, however, that all the parties are here before you. That is, both Mr. GRIER and the county have come to you and asked you to make a decision. So it's not as if, you know, there are different parties and some wanted you to make a decision and some didn't. Both of them have come to you and have asked you to make a call. Then there's a question of whether it's within your jurisdiction to interpret 46-4C. Mr. Geiger says, well, that's not in your jurisdiction. I haven't asked you to do it. But, you know, to be quite honest, when I read the petition, that is exactly what I thought he wanted you to decide. And I think that's a reasonable understanding of the way he framed the question, and then proceeded to spend 3 pages of his 14-page brief on 46-4C. So 46-4C does not seem to be, you know, or put it differently. Let's suppose you don't interpret 46-4C. And so what are you being asked to say? 205-2 and 205-5 says the density is 1 dwelling per 1/2 acre unless otherwise allowed by 46-4C. The answer would be what? You are allowed to have a higher density if allowed by 46-4C. That frankly seems like I'm not sure what word to use. It's such an obvious restatement of the law. It doesn't seem logical to me that that would be the subject of a dispute or the subject requiring any kind of any party coming to the LUC to ask for clarification. The clarification is, what does 46-4C mean? That's the clarification. And I think that's within your jurisdiction because it affects the density requirements in Chapter 205. Chapter 205 is clearly in your jurisdiction. It's clearly land use. So are Ohana dwellings. They are also land use. And they deal with the question of what can be done on lands in the rural district, which is squarely within, I think, the purview of the Land Use Commission. So from the Office of Planning's viewpoint, we think you can issue a ruling on this matter and clarify this for the parties. I'm open to any questions.
Thank you very much, Mr. Yee. Commissioner Chang, followed by Commissioner Okuda. And well, let's see, actually it's 3:40. We've gone 54 minutes. How extensive is your questioning going to be, Commissioners Chang and Okuda?
I just have one question.
Okay.
2 questions, Chair. I hope to keep it 3 minutes, not counting the response.
Okay, and Mr. Geiger, how long do you think you need for rebuttal or closing?
I would keep it fairly short, maybe 5 minutes max.
Okay. Well, let's try and finish up with Mr. Yee then, and then we'll take a break. We'll hear final thoughts from Mr. Geiger and perhaps proceed to deliberation.
Thank you, Mr. Chair.
Yeah.
Thank you, Mr. Yee. As always, I greatly appreciate your presentation. Let me just ask one clarifying question, because as you were describing what the counties or what the options are, you talked about a subdivision. So based upon your position, could the counties, could the petitioner come in to do a subdivision and then put more than 4 dwellings on the 2-acre lots?
Yes. If the counties approve the subdivision of a 2-acre lot into 4 different lots, each lot may be allowed to have 1 dwelling unit on it pursuant to 205-2, and then each lot may be allowed to have an accessory dwelling pursuant to 46-4C.
But isn't that contrary to 205, which says you cannot have more than 1 lot for half an acre?
More than 1 dwelling unit per half acre, except as allowed by 46-4C.
Okay, and so you're saying the subdivision, because that's contrary to what the county is saying. You're saying that under the subdivision, the county can exceed the 4 dwellings, because the county is saying under no circumstances can they exceed 4.
I think there might have been a misunderstanding, but I'll let the county answer that question.
Okay.
Thank you
But
very much. Sorry, would you like me to answer? Okay, the county's position was not under the circumstances of a subdivision. It was only if it was not subdivided. So under a subdivision, we fully agree with Mr. Yee as to the analysis of how many houses and or dwelling units per lot would be available.
Okay, so even within rural designation, if there's a subdivision more than 4 lots for 2 acres, that's your position, both the county and OP?
No.
Yeah.
No.
Well,
Let me be very clear about this.
Hold on.
I'm sorry if I could.
Sorry, we're just under questioning of Mr. Yee right
Yeah,
now.
I'm sorry. My apologies.
On a 2-acre lot, you could subdivide it as small as 4 half-acre lots in the rural district. On each lot, you may have 1 accessory dwelling. I'm sorry, on each lot, you may have 1 dwelling unit. And then after you have subdivided, each lot, which is a half-acre, may be allowed to have 1 accessory dwelling. It's not, you don't subdivide it with more than 4 units. You subdivide it, it gets 4 units, and then each lot is accessory dwelling.
So under your scenario, the subdivision would permit 4 dwellings and 4 accessory units up to, so there could be 8.
Well, assuming there are 4 separate lots that are created and each lot is 1 half-acre each.
But there could be a maximum of 8.
Yes.
Without the subdivision, a maximum of 4.
Yes.
All right. Okay. Thank you.
Commissioner Okuda.
Very quickly, Mr. Yee, I find your explanation very persuasive. My question goes to limiting the inadvertent damage we as a commission might do. As a legal matter, if this matter is just litigated through the Second Circuit Court on Maui, then the ruling really affects only the county of Maui. And if there's an appeal to the appellate court, the other counties can perhaps file amicus or what you would call advisory briefs to the appellate court. But generally, the ruling would be Maui specific. But if the Land Use Commission makes a ruling here, there is a very good argument that the DR order we enter would have statewide effect. Wouldn't that be kind of unfair to like the county of Kauai, the city and county of Honolulu, the county of Hawaii or Hawaii Island, that they might suddenly be taken aback by a ruling coming from us which they really didn't participate in. Wouldn't that be a concern? And the specific legal point I'm making is maybe we don't have a sufficient record to do this right now. Would I be totally wrong to have that concern?
There's legal and then there's practical. So let me distinguish those two things. Legally, under your administrative rule 1515-104, which speaks to the applicability of the declaratory order, the declaratory order is applicable to the specific set of facts as delineated by the Land Use Commission. So that's within your purview to determine how narrow or broad you want to draft your declaratory order. Practically speaking, and actually, let me just note that for a court order, I think you're right that a court order, especially at the circuit court level, is only applicable to the parties who are present, right? And like I said, unless they're in privity. So that's legally correct. But on both cases, there is the practical effect of if there is a court order on the meaning of a state statute, that will be persuasive to a number of different entities, including a number of different counties. We're not looking to litigate, right? They just want to follow the law as it's best understood. So whether it comes from the LUC or it comes from the court, the practical effects is actually, I think, very similar, if not the same, depending on, again, on how the order in each jurisdiction is framed.
Thank you.
Anything further, commissioners? If not, it's 3:47. We can do a couple of things. One would be, we hear from Mr. Geiger. So stretch a little past a full hour in a row and then call it a day and come back to deliberate tomorrow. Or we take a break, hear from Mr. Geiger and go into deliberations.
Chair, this is Gary Okuda. May I request indulgence of everyone if we can do this today, because tomorrow morning I have to be in probate court at 9 o'clock. I'm sorry.
Any concerns with that? If not, okay. And people said we could go till at least 4:30. So it's 3:48. Let's take a break for 12 minutes till 4 o'clock.
Maybe let's not take a break and let's just power through. I mean, unless somebody.
I have to keep in mind the court reporter.
Okay.
And basic biological needs of your fellow commissioners. So,
yeah.
So we will take a break till 4 o'clock.
Okay.
We're back on the record. It's 3:57. Mr. Geiger.
Thank you very much. Thank you, Chair. Thank you, Commissioners, for paying attention. It's been a long afternoon, and we do appreciate very much. I'm going to keep my remarks very short. There's just one point I wish to make. As has been recognized, maybe it has been recognized, but I've had cases with Brian before, and I've always appreciated Brian's comments because I find them usually spot on, but I do not always agree with Brian. And in this case, I do not agree with Brian. And the reason I don't agree with Brian is because if the legislature had intended to do that which the county and Office of Planning is saying, it would have been very simple for them to have amended 205-2C to state, except for one Ohana dwelling in 1/2 acre or less rural lots. Because that's the effect of what they're asking you to determine. But the legislature didn't say that, not in the legislative history, not in the statute. The legislature said for rural lots of whatever size, you can have Ohana zoning as permitted or as allowed by the county. The legislature said, leave it up to the county if they wish to have a higher density on rural lots than the default of 1 per 1/2 acre. And so I believe that for the commission to go beyond the statute and find anything beyond that the county can adopt an ordinance allowing for greater density would be in violation and contrary to the legislative history. And with those comments, I want to again thank the commission, the commissioners, and the chair, and as well as the commission staff for everything with regard to this hearing. Thank you.
Thank you, Mr. Geiger. Are there final questions for Mr. Geiger? Commissioners? Okay. If not, oh, Commissioner Chang, sorry.
I do apologize. I'm going to try to keep this really short. Mr. Geiger, the day has been very long. So as I understand your position, 205 says no more than 1 dwelling per 1/2 acre. So 205 says for except as otherwise permitted by the counties. And is your position that the counties can authorize in excess of the 4 dwellings, that they can actually authorize potentially up to 8, a dwelling and an accessory unit?
The counties can authorize additional Ohana dwellings, whatever the counties choose that to be based upon the particular circumstances of the land use that the county is addressing.
So if in your case, the counties have determined that that the maximum is 4 for each 1/2 acre, well, 1 dwelling per 1/2 acre, are you questioning the county's determination?
Yes, because the county is saying that's the limitation imposed by Chapter 205. The county ordinance allows for a greater number or density than allowed by 205, which they are entitled to do under Chapter 46. And so we are only asking that the county's ordinance would be enforced. But that issue is not before the commission, and we are not asking you to weigh in on that issue.
All right. Okay, thank you very much.
Thank you.
Anything further, commissioners? If not, I would, sorry, Commissioner Okuda, no? Okay. If not, I'll remind everyone and the audience that this is a hearing on a request for a declaratory ruling. As such, the decision of the commission will be made on the written briefs on file and posted to our website. This is not an evidentiary hearing. Any oral presentation made today will be considered in the commission's decision-making process. According to the commission's administrative rules, section 1515-100, within 90 days after the receipt of a petition for declaratory order, the commission shall either deny the petition in writing, stating the reasons for the denial, issue a declaratory order, or set the matter for hearing, as provided in section 1515-103 of the commission rules. In addition, section 1515-102 of our rules provides that the commission can, for good cause, refuse to issue a declaratory order by giving specific reasons. And as was discussed earlier, those reasons the commission may refuse where, 1, the question is speculative or purely hypothetical, does not involve existing facts or facts that can be expected to exist in the near future. 2, the petitioner's interest is not of a type that would give the petitioner standing to maintain an action if the petitioner were to seek judicial relief. And 3, the issuance of a declaratory order may affect the interest of the commission in a litigation that is pending or may be reasonably expected to arise, or 4, the issue or matter is not within the jurisdiction of the commission. So we may now go in, we will now go into conduct formal deliberations on this matter. I will note for the parties or the party and the county and the Office of Planning that during our deliberations, I will not entertain additional input unless those entities or individuals are specifically requested to do so by me. I'm going to go through and just make sure. Commissioner Okuda, did you have something
No,
to say at this
sorry.
point? Okay. I want to confirm that each of the commissioners have reviewed the record and are prepared to deliberate on the subject docket today. Commissioner Axon?
Yes.
Commissioner Cabral? You're nodding your head. Yes. Okay. Commissioner Chang?
Yes, I am.
Commissioner Giovanni?
Yes.
Commissioner Ohigashi?
Yes.
Commissioner Okuda?
Yes.
Commissioner Wong?
Yes.
Chair is also prepared to deliberate on this matter. Commissioners, what is your pleasure? Commissioner Okuda, I believe this is why you raised your hand.
Thank you, Mr. Chair. Pursuant to HAR 15-15-100, parent small a, close parent, parent 1, close parent, I move that the petition be denied.
Is there a second, Commissioner Ohigashi?
I'll second.
Okay. I'm going to ask you to speak to the motion and speak to the second in that order.
Thank you very much, Mr. Chair. I found all the legal presentations top-notch, well prepared, well briefed, and well presented. But based on what was presented, the reason why I have made the motion is I believe that under the specific situation that we face here today, the matter is speculative, as that term is used in HAR 15-15-100, parent A, close parent, parent 1, close parent, parent capital A, close parent. The reasons why the situation is speculative include the fact that there is a pending action has been represented to us in the Second Circuit Court dealing with the County of Maui and the petitioner. And so these issues still have a forum where they need to be and can be litigated, where a full record can be prepared on all the issues and where such full record can be appropriately reviewed. My reasons also include the fact that we have to be mindful of what the Hawaii Supreme Court ruled in the Save Sunset Beach Coalition case, which is basically that if the counties are taking a stricter view or have stricter ordinances or ordinances which are more strict than the state land use law, then the stricter ordinance or requirements prevail under the dual system of zoning that we have in the state. That frankly explains the reason why HAR 100, parent A, close parent, parent 1, close parent, parent D, close parent, essentially restricts the Land Use Commission from issuing declaratory rulings on interpretations of ordinances or other types of rules which the Land Use Commission does not have the power to administer or is otherwise not charged with interpretation. I understand the argument that Mr. Geiger has made. However, in considering all the arguments that were presented and the briefs that were submitted, it's clear that the ruling also hinges upon what the County of Maui believes its ordinances and rules require and their interpretations of those rules and ordinances. This ruling, of course, has nothing to do with whether or not the county is appropriately enforcing their rules, whether there may or may not be due process issues, but those are issues for litigation between the parties before the Second Circuit, and not something the Land Use Commission has subject matter jurisdiction, because we all know subject matter jurisdiction cannot be waived. So for those reasons and other good cause in the record, I ask that the motion be granted.
The motion to deny be granted.
Yes.
Okay. Commissioner Ohigashi.
I don't have any comments really to add to Commissioner Okuda's statement. However, I would note that there's much confusion in trying to facilitate or obtain the necessary facts that would support this. Petition for a declaratory ruling, and therefore I support Commissioner Okuda's rendition or determination or motion, actually his motion that he made.
Commissioners, we are in discussion. We have a motion before us to deny the petition. Commissioner Chang, have you run out of words at this hour?
Commissioner Okuda and Commissioner Ohigashi's comments have said it all. I have really nothing more to add. I think that we've had a robust discussion today on the facts, the legal issues, and based upon all of that, I support the denial of the petition for declaratory order. So that is all that I have to say, but thank you very much.
Okay. Commissioners? Commissioner Cabral? You're muted.
No, I agree. I'm going to vote in favor of the motion to deny. I feel that I'm confused about it still, but I don't think it's our place to work on what I would consider perverting the law with zoning. Thank you.
Commissioners Giovanni or Axon?
I have been swayed by Commissioner Okuda as usual, and will support the motion.
Commissioners Wong or Axon?
I've got nothing else to add, Mr. Chair.
Okay. The chair will also be voting in favor of the motion, joining in the good arguments of Commissioners Okuda and Ohigashi. If there's nothing further, Mr. Ordenker, would you please poll the commission?
Thank you, Mr. Chair. The motion is pursuant to section 1515-100 1A, that the petition, A1, sorry, A1, that the petition be denied. Commissioner Okuda.
Yes.
Commissioner Ohigashi.
Yes.
Commissioner Giovanni.
Aye.
Commissioner Chang.
Aye.
Commissioner Cabral.
Yes.
Commissioner Axon.
Aye.
Commissioner Wong.
Aye.
Chair Scheuer.
Aye.
Thank you, Mr. Chair. The motion passes with 8 affirmative votes.
Okay. I'd like to sincerely thank Mr. Geiger, Ms. Tarnstrom, and Mr. Yee for their presentations today. And we appreciate it very much. It's very helpful to us.
Thank you, Chair. Thank you, Commissioners.
Thank you, Chair and Commission.
Thank you. Before I declare recess till 9 a.m. tomorrow, I want to briefly go over our schedule. We will, having dispensed with this item, move on to return to the Hokua Place matter. However, I want to confirm that we have quorum to proceed. Commissioner Okuda will be absent from 9 a.m., possibly till 10 a.m. Commissioner Giovanni will be absent from 9 a.m. to 10 a.m. and Commissioner Chang will depart at 10:30 a.m. Commissioner Axon?
Mr. Chair, I'm going to leave for an hour around 11:30, but I'm trying to get out of it. So
Okay.
I believe
If you need me to write a note, I can. So, Mr. Ordenker, how many, can we proceed if we have 2 absent commissioners and we have 6?
Yes, we can, Chair.
Okay.
As long as we have 6, we can proceed. Actually, as long as we have 5, we can proceed, but 6 is more comfortable.
Okay.
Is Brian Yee going to be there?
Sorry for you, but yes.
Is there any further business today?
This is Nancy. I want to thank Mr. Yee for affirming that I'm not crazy about condominium requirements. Thank you.
The chair will note that the affirming that you were not crazy only pertained to condominium requirements, not into any other matters. And there being nothing more, I declare this meeting in recess till 9 a.m. tomorrow morning, April 15th, 2021.
Thank you, Chair. Thank you, everyone.